No matter where in the world, we love Guyana. What are your colors? How do you represent? I love Guyana. Order yours today. We ship worldwide. Delta 9 Media.
One love, one people, the mission complete. One love, one flag, one nation, right? Under the stars, divine presence in the sky. Unity, no war, let the children thrive. Power to the people, we keep hope alive.
The rights of the individual and how the minister's issuing of the ATP impacts those rights. And if you could tie that up with your allegation of, I take it, apparent bias, presumed or apparent bias.
Well, the Court of Guyana did not address that issue. The Court of Guyana did not address the issue. The Court of Guyana says that it was...
The Court of Appeal.
The Court of Appeal of Guyana. The Court of Appeal of Guyana says that it was a pure administrative function. The Court of Guyana, the Court of Guyana did not address the various allegations of bias made, and they skipped that issue. And the Court of Guyana disregarded fundamental impact that Section 12 would have on the proceedings, and the Court of Guyana did not take into consideration that the Section 12 right is a procedural right, which is preliminary according to guarantee, which provides a procedural fairness, and which is a right which is consonant to the equivalent of the protection of the law. Because what you're doing is you are denying the person the protection of the law provided by Section 12, which is a statutory right given to you to have an unbiased adjudication on this issue. It does not matter if the adjudication is right or if the adjudication is wrong. It is the standing of the person, the decision maker, who has the duty to adjudicate on these issues and to assess these issues. And those issues are identified in the Act because Section 12 says, in accordance with the Act, and I've identified those sections which the minister has to take into consideration. And therefore, if she's not given that right, he's denied the protection of a statutory right given to him.
You said earlier, Mr. Hussain, that the minister must make sure that she is not biased. That's an interesting way of putting it. You would agree that the Act allows for the government to authorize proceedings for extradition against persons who are in the political opposition, would you not?
Well, our case was never because you're a political adversary that the minister can't adjudicate in respect of Section 12. That is not our case at all. Our case is that having regard to what is said by the Attorney General who advised the minister on the form, and therefore he must have been satisfied that all the requirements of specialty, all the requirements of double criminal...
We understand the requirements, not to interrupt you, Counsel. But I did think that when I read the Court of Appeal judgment, and when I read some aspects of your submissions, I thought you were saying that by virtue of the office that the minister had and the connection between the minister and the government, the minister was automatically disqualified from granting the ATP. Am I wrong?
We put it differently, Millard, in respect to this. We are saying that the minister, first of all, was present, had a collegiate relationship, had a fraternal link with the president and the vice president, who attacked the courts, who attacked the fact that these people are criminals, they are murderers, they are robbers, they are thieves. This is just not pure political banter. This is the environment in which the minister operated. She was at those meetings. She belonged to that party. She belonged to that cabinet.
Yes.
Is that the policy?
Yes, I hear you. I'm not sure if this is part of what Mr. Ford will address.
No, that is part of
that is part of what you are addressing. Okay.
Okay.
I understand that, and we may very well come back to that in due course. But I just want to ensure we are on the same page.
One of the issue there which I may feed into.
Sorry, if I could comment and then you respond. I just want to make sure we're on the same page, because by definition, if a minister has responsibility to authorize proceedings for extradition against a political opponent, it is not difficult to infer or to suggest, better word, that the minister is biased, because there's almost always the case that there's going to be some kind of political, perhaps, advantage, political implication of the government authorizing the extradition or proceedings for the extradition of a political opponent. So that is the structure under which we operate. That's the architecture of the statute that we have to face. And therefore, a minister exercising the powers granted by the statute could not, by that fact alone, be said to be biased such that the minister cannot exercise those functions.
I agree with you absolutely, my lord, except in this case, we say there are at least 35 occasions, almost as a matter of policy, where criticism during an election campaign and following an election campaign were directed against these two individuals: sedition, treasonous behavior, flight for extradition, tax evasions, and criminality. So therefore, what makes this case different from a normal minister is the extent of the vitriolic statements meted out against these persons. And in that situation, there's an exhibition of bias. And the exhibition of bias continues after the March 18 was issued, and the courts are entitled to take that into consideration on the basis of conjoint, where the court took into consideration matters after.
Counsel, on that point, and this is of interest to me, your entire case about bias is on that. What?
I beg your pardon, I'm not hearing you.
I said your entire case on bias is built or based on what the complaint is that the politicians who are now in ministerial position, public office, what they said against your client. And you mentioned at least 25 occasions on the political hustings. Now, here's my question. As I read the materials, your client said that he is the foremost critic of the government since June 2024. Now, here's the interesting thing about that. And references were made to some of the things he said. He even suggested for people to look at Facebook material. Our legal staff were able to pull up some of those for us to see. And he doesn't describe precisely in his affidavit and your submissions the terms in which he had been criticizing the government since June 2025. But on looking at some of the videos we saw, it becomes apparent that he alleged corruption and mismanagement against the government. Now, I'm not interested in inquiring in the facts of that, whether or not corruption or mismanagement occurred. My question is this. If a political opponent accuses another political opponent of corruption in office, what does that person making that allegation expect from the opponent that has been accused of corruption? Here's where I'm going with that. You and I were lawyers. We know about that concept of provocation. Is it possible that, I'm asking a question now, I'm not making a conclusion. Is it possible to say that your client might have drawn that speech fire, as it were, when he started, or when he called the government corrupt? Is the government entitled to reply in kind? That's one question. Another factor to this is by June 2024, when he said he emerged as the foremost critic, that was a whole 11 months after a certain publication of allegations against him made by Reuters News in an investigating reportage, where they blatantly accused him and his father of criminal conduct. That was in July 2023. So almost a year later, he emerged as the foremost critic of the government, calling them corrupt. Does that give a color to this case in any way?
I have three answers there, Milan. The first answer is that the court is focused on the decision maker. And my client is not the decision maker under Section 12.
But could he have provoked the circumstances that are now being referred to as bias against him? Because in 2023, from what I'm reading of the materials in this case, they were not an opposing camp. They were supporters of the government. They say that. He says that, and I believe there's a video where his father also says that. They were strong supporters of the government. They helped the government get elected into office. A number of issues come out of that. Did this allegation of corruption, was it since June 2025 that the government started being corrupt? Or the reason all this is important is because the Attorney General, the respondents, are arguing that the appellants are now trying to use politics as something of an immunizing effect for them. So that when you hug politics, then you can say, sorry, you cannot extradite me because I'm a political foe. The question is, was this political foe enmity? Was he implicated in the circumstances in which that enmity arose?
Okay, I think we have the question. Counsel?
Well, could I just answer those questions, Manoj? The first issue is that the decision maker is not the opposition. The decision maker is the minister. And the minister's fraternity is the one who made the statement that were biased. That's the first point. The second point is that the statements that were made were pro-extradition statements even before the ATP was issued. And that is what you need to focus on. That's the second point. The third point is that the statements by the government cross the boundary of political banter, because what the learned friends have sought to do is to temper down or reduce the extent of the criticism and the allegations of sedition, treason, flight to Venezuela, cohorting with a country that is almost in an adversarial relationship with Guyana, that is Venezuela, and their claims to the territory, and therefore the criticism will cross the boundary of political banter. Now, the fourth point is that, my Lord, we are not asking you to assess, and respectfully, the court may not assess the Reuters report or any allegations made in respect of these applicants, because to assess the banter back and forth is not the issue. The issue is whether the minister and her fraternity crossed the boundary. And the final point I want to make, dear Millard, is that the minister received the advice of the Attorney General, who had gone on record as criticizing not only the magistrate, but also criticizing the entire speed at which the extradition proceedings were taking place. And the Attorney General himself said that he advised the magistrate. Now, in the light of that, advising the minister, I beg your pardon. In the light of that, if the Attorney General said, I helped her and advised her in filling out the form. The filling out of the form is a satisfaction that all the matters which the minister had to consider under Section 12 have been satisfied, extraterritoriality, specialty, etc., etc. And if certification and all that, if it is that if that form is filled out, the minister is satisfied. The participation of the Attorney General in that exercise makes him almost a party to the decision and a party to the dais, especially when he advised on the case law, he advised on the form, he was a legal advisor, he participated in the vitriolic criticism that crossed the line, he commented adversely on all the extradition matters. Even before the ATP was issued, he said the Americans had enough evidence on them. And therefore,
Consul, yeah, I think we have you. But you're in a place I wanted to have visited, because I wanted to have asked you whether your position would not be much stronger if one of the persons who you point to as uttering these statements was in fact the Minister of Home Affairs. So I think you've identified three persons in the government, highly placed in the government, who, in your view, made remarks which went beyond the boundary, so to speak. But none of those three was the Minister of Home Affairs. So I'm asking you whether you would not be in a much stronger position if the Minister of Home Affairs was one of those three persons.
Well, I take you the case of Hello Miller. In that case of Hello, right. Fatima Hello, right? Now that was a case in which allegations were made against the judge who belonged to an organization where he was very deeply critical of Muslim Palestinian Jews. The statements made in a magazine and an organization which he belonged to. So therefore, he belonged to an organization. The organization published articles that were very detrimental to the applicant because of her race, and described that particular situation in Palestine in very pejorative terms. And Lord Mann said that if it is that those statements are in fact made, that it would be sufficient for disqualification for the judge to have taken. In other words, he would have to disqualify himself. So it is not the person who has made the statement, it's the fraternity where you belong to. So therefore, argument of our case in respect of the Minister of Home Affairs was as follows. First of all, she was present at all of those meetings and spoke. Secondly, she belonged to that fraternity. Thirdly, she had to have at least heard it and accepted and believed in it because that was part of the campaign. She wore the campaign jersey. She associated herself with those persons. She took advice from the Attorney General in respect of that persons. And in one instance, she mocked the second name applicant.
Or Mr. Hussein, I think we are getting tight on time and we understand what you're saying. So that what I want to President, if you would allow me to intervene, if you have finished.
Please.
If you have not, I'll wait until you're finished and then intervene.
No. I was going to make the very point you made, my brother, that we will have to move on pretty soon because we do want to hear from Mr. Ford, of course.
Yeah. So if
Yes.
I'll be short in what I want to ask. So Mr. Hussein, you have framed your client's positions as in a sort of reductionist way, meaning this. Because of the fraternity argument, no one on the government, on the executive side, because this minister or any other minister would be on the hello case, the fraternity argument, be infected by the bias of these three senior people who you've identified and for the reasons you've given. We don't need to rehearse the facts. Is there a more pragmatic and reasonable middle ground where to honor procedural fairness, to recognize that accepting for the moment your contention, it is bias and not the open mind, genuine decision maker sort of threshold, recognizing and acknowledging that bias infects the process, irrespective of rationality or proportionality of the substantive decision. Is it not a more pragmatic and reasonable middle ground to say that where there is evidence that a particular decision maker is infected, in this case, maybe because the direct advice was from the Attorney General, or as the President has said, this minister made similar remarks, to say such a person would not be impartial and independent decision maker. But it is not to go so far to say no one can ever make such a decision on the current executive side. The reason I ask that, I'll just finish quickly and then allow you to respond, Mr. Hussein. The reason I ask that is because we have to also, I think, operate within the social context of pragmatics. That is to say, we operate in a system where we want criminality, if it is reasonably being prosecuted with all the various standards, we want to prosecute criminality. We want to facilitate proper extradition proceedings. That must be a proper policy of rule of law and governance. However, we want to balance that against processes that may be tainted for public trust and confidence, rule of law, protection of law arguments. I get all of that. Why is there not a middle ground where, if that is raised, as you have at the first stage, before time, energy, expenses have gone on, for that determination to be made, and as in judicial review, a legitimate option is reconsideration before a different and more impartial and independent decision maker?
Absolutely, Miller. Absolutely. And my little friend, Mr. Ford, will address the Carlton delegation, will address the issue of some other person can do it. There's no reason why. In the case of Froome, that decision is routinely taken.
So that for you, thank you. So for you, your outcome on this is not that this must be quashed in.
Absolutely not.
It is simply that this particular reference of the ATP infected, the minister being infected by the Attorney General in particular, because of what you allege. I'm not suggesting I think that way, that makes it a corrupt, I use that technically, I don't mean it otherwise, a legally corrupt decision. And therefore it should be remitted to an impartial and independent alternative decision maker for reconsideration. That would be acceptable to you and your clients?
That has been our case all along the way, Milan.
No, but I misunderstood you. I apologize. I thought your contention was there could be no possible.
At the Court of Appeal, we're not saying that this is the end of the extradition at all, or the request. What we are saying is that exactly what Millard has so eloquently put, that another official who is not biased could do it under Kaltuna, under the Interpretation Act, and my learned friend Mr. Ford will address that issue.
All right, thank you.
Yes, you said Mr. Ford will address that issue?
Yes, my lord.
Wonderful. So if you don't mind, Mr. Ford, I think we are all ears. Now, I think we have asked so many questions of your colleague that it would not be fair to leave it only 4 minutes. So we are going to give you some more time, but please be as concise as you could be. Please. Thanks.
I just kind of one point before I leave, my lord, and that is I think you have brought it. There are two ways of approaching this issue. The first way is the way that the learned friend has suggested. And in all of those cases, those are policy positions. In the cases Imperial Oil, Franklin, those are policy issues. Those are political issues, political promises. Those are developmental issues. Those are environmental issues. And in that case, what you have is a minister approaching the matter with an open mind, and the cases all speak to that. This is a case about rights and interests, and therefore, what happens is in that situation, this is a case that has to be approached from the point of view of bias, whether apparent bias or presumed bias, and therefore, an anxious scrutiny according to Bugade and according to Ferguson and Dalgo, and saying, and Froome as well, anxious scrutiny of the rights. And therefore, that is the distinction. The distinction is that you can't tamper down what it is that the state has, what the state actors have said in the matter. But what you can do is you can apply the appropriate test, not.
One love, Delta 9 travelers. I'm telling you, this is the hearing that we've all been waiting for. So much interesting details and so many headlines. Please and thank you. Remember, thumbs up this live so that persons will be able to see this one wide and far and be updated with all of this very important information. I'm telling you, win is right now. The leader is fighting for his and his father freedom. Drop it into the comment section. We're not going to be accepting any calls right now, obviously, because of the hearing. But what you can do is make sure that you thumbs up the live and share the live. Big up to all the travelers. One love.
Should not approaching the issue with a clear mind, but understand it is adjudicative or non-adjudicative, applying Javanti and delegating the power to someone else. And that is essentially what our case is. The approach is different, and Mr. Mendes' cases all deal with a clear mind, with a statute, with a minister dealing with planning.
Yes, I'm sorry, I don't mean to be disrespectful, Council, but I think you have made that point before, and you have now left Mr. Ford with 2 minutes. So,
thank you very much, sir.
Thank you, sir. Yes, Mr.
I'm going
Ford.
to give Mr. Ford my seat. I apologize for interrupting.
No need to apologize. That's fine, sir. Thank you.
I'm a very enthusiastic person, and
Please, sir.
Good morning, Your Honors. Your Honors, just to continue from where Maloney Senior left off, sorry, and the questions raised in relation to the issue of delegation, it is not our case at all that because of what would have transpired, that this means that this is the end of the extradition proceedings. And I was very heartened by the question asked by Justice Jamada, because it positioned our case in a very practical and realistic way, a way has not been captured in the decision of the Court of Appeal or at first instance, where our arguments have been portrayed as one in which we're simply saying that this bias, no other minister could deal with it, and that is simply the end of the matter. Your Honor, we have cited and relied on the Section 27 of the Interpretation Act, which we believe provides a broad and general power for the minister to delegate statutory functions under the Fugitive Offenders Act. The Fugitive Offenders Act does not prohibit, either expressly or explicitly, the possibility of a delegation occurring, let's say, by the very minister. Section 27 of the Act, Your Honors, provides the power to delegate. It's been the argument on the other side that what we contemplate is an ad hoc delegation. Bearing in mind the approach to be very realistic, we believe that the section permits a delegation for the purposes of the case. The minister is entitled after the completion of the exercise of that delegation, that function, because of the peculiar circumstances of this case, to revoke the delegation if they wish, and to resume the full exercise of the powers vested in the minister on the
May I ask you, Mr. Ford, is the power as you conceive it to delegate at large? Can the minister delegate to anybody?
The section says, section 20.
Yes, we're familiar with the section, but I'm just asking you whether the minister could delegate to anyone, or would it need to be another minister? Because as you know, the FOA speaks in terms of the minister exercising certain functions.
Yes, sir. Yes, Mr. President. Your Honor, the section refers to the exercise of the delegation by the minister to any public officer. Section 27 refers to the exercise. Is now moving.
Mr. Ford, after you finish the president's question, I would like you to go to section 6 of the FOA and see whether that gives us a context. But finish the president's question first.
Section 6?
Unless you're finished.
Section 6.
Yes. See whether that tells us anything now about how to read section 12. Section 6 says, here is about the certificate from the Minister of Foreign Affairs. And it said certificate issued by the minister assigned responsibility for foreign affairs or on his behalf by any other person authorized by him. So you see section 6 explicitly recognizing that in the case of Minister of Foreign Affairs, explicitly saying or on his behalf by any other person authorized by him. But section 12 doesn't say that. Are you saying that the Interpretation and General Clauses Act is a cure-all?
Yes, Your Honor. I say that section 27 of the Interpretation Act, notwithstanding the difference that Your Honor would have pointed out between section 6 and section 12, whereas section 6 specifically confers on the Minister of Foreign Affairs the power to have someone authorized by him to issue the certificate. Section 27 of the Interpretation General Clauses Act is broad enough, Your Honor, to permit the delegation by the minister to any.
But the minister looking at section 6 and 12 may well say, well, since section 12 doesn't say anything of the sort, as we see in section 6, I am not free to delegate. Because section 12 should have told me the same thing it says in section 6, but it doesn't. That's a question for you.
I agree, Your Honor. But, Your Honor, that position would be very unduly restrictive and not take into consideration section 27 of the Interpretation Act, which says where any written law confers any function on the president, the minister, or specified public officer, the president, the minister, or the specified public order or officer may by order delegate any public officer to exercise such function. So section 27 is a very broad section, which would effectually be taken to be read as part of the as part of the Fugitive Offenders Act, which would have the same effect as section 6, because it would imbue the minister, the Home Affairs Minister, that is, with the similar function and power to delegate as expressly set out in section 6.
Mr. Ford, can we interrogate the question? It began with the president in a slightly different way. In the Act, the FOA, where is the minister defined?
It's not.
Your Honor, that is one of the issues that I wanted to deal with as it arose this morning. There is no specific section in the Act which says that it must be the Minister of Home Affairs. It simply says the minister. The Court of Appeal of Guyana in the King's case said that by tradition and by general understanding, the specific function is to be exercised by the Minister of Home Affairs. So that is how the whole issue of it being the Minister of Home Affairs. As a matter of fact, Your Honors, and you would have read in the submissions of Mr. Mendez, he has basically extrapolated from that by virtue of the fact that we would have written letters to the Minister of Home Affairs, that we would have gone into a situation of waiver, and we would have been duty bound to acknowledge the Minister of Home Affairs as the person to exercise the section 12 functions in relation to the issuance of the ATP, which is another issue which I'll deal with. But Your Honor, there's no specific section in the Act which says that it must be the Minister of Home Affairs.
I raise that because that would be in contradiction to Section 6, because Section 6 is referring to a certificate by a minister whose roles and responsibilities are described, i.e., responsibility for foreign affairs. So
yes,
Section 6 clearly points to a minister who has in their portfolio responsibility for foreign affairs. You would agree with me on that, right?
Yes, Your Honor.
It would appear that Section 12 does not do what Section 6 did, and which Section 12 could have done, I imagine, because Section 6 did it, and suggest any sort of responsibilities. That's what I was trying to get at. Is there anywhere in the Act that does what Section 6 does, which sort of points to the responsibilities that are in a portfolio when it speaks to the minister?
Your Honor, there's no section in the Act which assigns or identifies or describes in any way the portfolio of the minister referred to in the Act as a minister.
But Mr. Ford, the minister under Section 12 surely cannot be any minister in government, because that would then mean that the Minister of Environment could be dealing with extradition, because the provision says the minister. Doesn't it mean that the Minister of Finance can make that claim? So there has to be a way of rationalizing what minister means in Section 12, isn't there? And how do we do that in the absence of a definition?
Certainly, and I agree with you, Your Honor. Under the Constitution, the President is the repository of all ministerial authority. The President can assign a wide range of portfolios to specific ministers. So it is the minister, the President can assign that portfolio to any minister. So we may end up with an amalgam situation where the Minister of Foreign Affairs and the minister, it is also the minister who has responsibility for extradition. It is possible under the constitutional scheme. The President also could decide not to identify
Mr. Ford, that's what I was trying to get at. Don't we have to look in the ministerial portfolios for the relevant roles and responsibilities then? In other words, you can have, suppose there was, the President can create any ministry. Doesn't have to create a minister or a Ministry of Home Affairs, But what we may have to look at is the roles and responsibilities, just like in foreign affairs, right? So the question is, when you look in the relevant portfolios, is it that the Minister of Home Affairs is the one who has the roles and responsibilities that most align with the treatment of extradition proceedings? In Guyana right now, that's what we're asking, I think.
Yes, I would invite you to answer if you can, but do bear in mind that we have limited time, and I'm not quite sure where this particular issue is leading. But please, yes.
Your Honor, I must concede that I cannot specifically recall what are the specific statements set out in the ministerial orders issued by the president after the last elections in relation to the allocation of this specific responsibility. The case has, however, proceeded on the basis, from at least from the by virtue of the exercise of the function by the minister, on the basis that that minister, Ms. Wonish Waldron, the first name respondent, is the minister who has the responsibility historically, and who, by virtue of the exercise of the function, is presumed to have been the minister imbued with the authority. We have not specifically challenged the issue of the exercise of that minister by virtue of portfolio, from a portfolio perspective, Your Honor.
So nothing much turns on this, does it? I'm just trying to follow the issue. Where we got into this, but I was asking you whether there were any restriction on the ability of the minister to delegate. And you said that the minister can delegate to any public authority. Was that it?
Yes, Your Honor. And Section 3.2 of the Interpretation and General Clauses Act says that the Act shall apply unless expressly otherwise provided to all written law. So it reinforces my point I was making.
But my brother, Justice Ibu Osuji, raised, I thought, a very interesting point, because you were saying that there's nothing in Section 12.2 that would suggest that Section 27 is not applicable. Whereas he pointed to another section in the FOA 6, which clearly allows for somebody else other than the minister to participate in the functioning of that section. And Section 12.2 does not have an equivalent provision. So I suspect by implication, the question is, or the proposition is that Section 12.2 does not allow for the application of Section 27.
And my answer, Your Honor, is that the Interpretation General Clauses Act, specifically by Section 3.2 and by Section 27, does exactly the same thing as what Section 6 does expressly in relation to the Minister of Foreign Affairs, in that it specifically provides for the delegation by the minister, whoever the minister may be, who has functional authority or superintendence over the matters of extradition, to engage in a delegation. The section says that this act shall apply to all laws, and Section 27 specifically says that the minister, the president, shall have that power to delegate any function under law, under the law being, of course, Section 12, to delegate that power to a minister, so the public servant. So effectively,
we have your submission on that, not a difficulty. Could I just ask you though, with the decision of the minister to delegate, given your point of view that the minister could delegate, would that then be subject to judicial review? If the minister delegated, in this case, her functions to another minister, would not the problems that you have with the current minister also arise there?
Your Honor, interestingly, Section 27 does not permit the delegation to another minister. It permits delegation to a public officer, which in the context of it may be interpreted to include by definition a minister, but my interpretation, Your Honor, which is favorable with a realistic, fair, and just determination of this case, in view of the principles outlined by Justice Jamadar, the need to have criminal processes flow while at the same time protecting rights and having a balance. It is nothing prohibiting, Your Honor, the minister from exercising the delegation power to delegate it to a public officer.
Of her choosing.
Other than a minister.
Yes, I'm not quite sure where there's that limitation. But in any event, what I'm asking you is that the minister, under your theory, can delegate her powers to any public officer of her choosing.
Yes, Your Honor. And that is
would you not have the same kind of issue then, Mr. Ford?
No, Your Honor. Because, Your Honor, in the case, for example, not exactly in the same antecedent facts, but in the case of Froome, the minister delegated to a lawyer in the ministry in Canada the power to issue an ATP, and the court upheld the exercise of that delegation and the validity of the ATP in that case.
Is that included in your submissions?
Yes, Your Honor.
Yeah, thank you. Okay, we'll look at it. Thank you very much. I think we follow you on that point, Mr. Ford. Is there any other point you wanted to urge on us, either in delegation or otherwise?
Just truly discretionary factor that she could have taken into account. Peculiar to the minister.
Your Honor, so we would have relied both on the very Interpretation Act and the Cartona principle as expressed and upheld in the Froome case. As a matter of fact, it's at paragraph 8 of our affidavit, of our applicant's reply to the Attorney General's submissions. He specifically referred to the Froome case and to the paragraph 139 upon which we rely in that decision. So there's no need for me to read it. And we also refer to, Your Honor, to the fact, to the Bourbas case, where the court recognized the Cartona principle as not being either one of agency or strictly one of strict delegation, but the person would be in effect exercising the constitutional power of the minister. Your Honor, nowhere in the decisions, both at the first instance or in the Court of Appeal, did the court engage in any analysis as to the possibility of delegation. The court felt that Section 27 did not permit a delegation at all that would be capable of being executed and implemented. In these circumstances, the court did not consider any question in relation to the applicability of the Cartona principle in relation to the implied power to delegate by the minister. I don't think that I could do much more having regards to time in relation to the delegation questions, Your Honor, unless there are any further questions.
I think we understand you fully on that point. Mr. Hussain said you'd have dealt with the issue of the tests as well for special leave. Did you want to say a few words about that?
Oh, yes, Your Honor. Your Honor, before just going to the question of special leave, I'd just like to stitch in quickly, just a quick point on the issue of waiver and necessity. Your Honor, flowing directly from our arguments on delegation and the Cartona principle, it is our submission that having regard to these principles, the question of the doctrine of necessity does not apply. We relied in our submissions on the case of Metropolitan Fire against Churchill at paragraph 10 of that very reply submissions to point out that it has said in that case, and it's a matter of common sense and prudence, that if there's another person or entity to make the decision, the whole question of necessity would not arise.
You are on hold. I'm not sure why. Are you answering another call? You're back. Yeah, we are back. You're back with us now, Mr. Ford, please.
Yeah, there you go. I apologize, John. I think we lost communication for a few seconds there.
Yes, no, that's fine. Please go ahead.
Can you hear me, Your Honors?
We can hear you and we can see you. Please proceed. Yes.
Maybe he's having technical
Are you hearing me,
issues.
Your Honors?
Yes.
If you're hearing me.
We can hear you, yes.
You're saying that they hear me. So let's
Yes.
continue.
Yes.
Let's go. Your Honors, so in the case of the Metropolitan case, the court identified a test in relation to the applicability of the doctrine of necessity. And the court said that the court must consider all the justice of the case. And the court actually outlined a criteria in relation to the conduct of the parties, including the conduct of the parties in relation to the applicability of the doctrine of necessity. And this is paragraph 11 of our reply submissions. But interestingly, Your Honor, paragraph 160 of this case, the court focused in on the question of the conduct of the adjudicator in relation to the questions of whether the doctrine of necessity must be applied. And we respectfully rely on this, Your Honor. The court says that where the issue that is the source of concern as it stemmed from a result of the conflict of the voluntary collateral act of the adjudicator. Now, those are circumstances which would point to the inapplicability of the doctrine of necessity in those circumstances. And in this case, Your Honor, having regard to all that has transpired, to the statements made, and I just wish to add that we have complained of about 30-something statements, 35 statements. They cover a wide range of things. But among the stuff or the content of it, Your Honors, there are specific statements by the President, the Vice President, and the Attorney General that go directly to the issue of extradition. So there may be statements which the court may feel that are substantially that of the political battle and back and forth. And we would understand that, but we still say that in relation to them, they show bias. But if we distill them here, there are sufficient statements made by the persons identified that go directly to the question of extradition, statements prejudicial to the question of extradition, statements showing a fixed understanding and comprehension in their minds that extradition is to take place many months even before the extradition process would have commenced, and it would have continued unabated, specifically led by the Attorney General.
And remind me how is this connected?
Would have criticized the magistrate continuously in relation to the issues. And I know you would have heard us on that, and you would have read what we would have said in relation to those matters. The other question that I really wish to raise, Your Honor, is that of waiver. Your Honor, the respondents have raised the question of waiver, and they rely on their cross notice of appeal in this matter. It's very interesting, Your Honor, that paragraph 2 of the cross appeal, they have identified their concern in relation to waiver. They've said that the applicants waive any right to object to the issuance of the ATP when by correspondence issued by then counsel for the appellants regarding possible imminent extradition. No objection was made to the minister exercising her power to issue the ATP. The first point we wish to make, Your Honor, which goes without saying, but we wish to make it nevertheless, that the burden of proving waiver lies on the respondent. And in this case, they would have failed to do so. In order for waiver to operate, it requires that the party would have acted freely and with full knowledge of all the facts. And in relation, that is the Pinochet expression of the principle. And in the local bill case, that the applicants with full knowledge of all the facts relevant to the decision, waiver or not, would have acted. Your Honor, in this case, the evidence shows that in relation to the Attorney General at least, his involvement was only made known to us, was never disclosed by the Minister of Home Affairs, by any other person, but was only made manifest when an affidavit in answer of defense was filed in the very proceedings in the High Court. So we respectfully submit that we clearly did not have or could not have all the information required, all the relevant knowledge and all the relevant facts within our client's knowledge or awareness at the time of the 31st of October when the ATP was issued. Your Honor, the letters relied on by the learned friend, Mr. Mendez, do not.
Mr. Ford, can you hear us?
5 minutes.
No, he cannot.
Do not
I'm trying to convey to counsel that he has 5 minutes
of any
remaining.
unequivocal election by us. There are two letters simply asking for domestic investigations, and the other one asking for indicating that my clients will not abscond the extradition process. They do not indicate any unequivocal abandonment of any rights. Your Honor, in relation to the question of the
Your Honor, may I suggest that we pause so that Mr. Ford can hear what you're saying?
Yes, I think that's a fair point. Thank you, Mr.
We
Mendez.
respectfully, Your Honor.
So, Madam Deputy Registrar, we will pause for 10 minutes and come back to hear the end
we
of
respectfully
Mr.
rely
Ford's
on
submissions.
the authority of Lynn Mine.
Thank you, Court Adjourned. We will try to contact Mr. Ford and Mr. Yes. President. Thank you.
One love, Delta 9 family. What are your thoughts? What are your thoughts? Everyone heard the arguments. Do you guys think that they're gonna put through the extradition? Do you guys think that no, the extradition is not gonna happen? Let us know. They're taking a break at the moment, and we're gonna be showing you guys right as soon as they come back. Let us know your thoughts, Team Delta. We're here live checking out what is going on with this CCJ hearing. No matter where in the world, we love Guyana. What are your colors? How do you represent? I love Guyana. Order yours today. We ship worldwide. Delta 9 Media.
One love, one people, the mission complete. One love, one flag, one nation, right? Under the stars, divine presence in the sky. Unity, no one, let the children thrive. Power to the people, we keep hope alive.
A natural way to stay ready, baby. Cause I'm ready for you, Mr.
The US
C.
is 100%
The ultimate meal
committed.
supplement. Men's total wellness formula. Packed with essential nutrients for men's health. She'll call you Mr. C.
What timeline or outcome is Washington realistically expecting at this stage. And just this past week, we saw that the case is far to push back. It's now going to be, at least the case in the magistrate's court is now set for a continuation on the April 7th.
Right. Well, it is in your court, and I think that's the key point. It is a process. We've done our part, and now it's with your court. We don't have an expectation or a timeline because it's not ours to control. So when the decision is made, it's made, and we will proceed from there. We are ready today. If the magistrate made a decision today, we would move forward with the process. But that is not within our control, and so we are patiently waiting to see what happens.
Now, one of the arguments put forward is that, and it's a claim, particularly by the Mohammed's, that this whole extradition, it's politically influenced and motivated, and there's also concern that, you know, if they're extradited, that there could be some, you know, it could destabilize Guyana to some extent, politically at least, the landscape.
So the United States does not pursue criminal charges for political reasons. We do it because we have hard, unequivocal evidence against a person. Why would we take on a case we don't think we're going to win? That's just a waste of the US taxpayers' money. So we firmly believe that they're guilty of the crimes that they're being indicted for. It's in the Guyanese judiciary's hands at this point, and you know, we're ready to move forward. I hope that's not the case here in Guyana, because I hope that destabilization doesn't occur. I mean, that would be really tragic, because we're simply holding people that we believe are guilty of a crime accountable for that crime. And to be fair, it's not just the United States taxpayers.
This, okay? It was basically the nail in the coffin. Azzuddin Mohammed becoming the opposition leader. It was the nail in the coffin. I knew this all along. I didn't say anything because I knew everyone would say I'm lying. I'm being paid by the PPP to lie. I'm this and that and this and that, because so for the Americans watching and for people internationally watching this, the people of Guyana, those people have been basically through a massive mind experiment of just mental and emotional abuse for decades. I mean, it's been mentally and emotionally savage for the people there. And so anyone who speaks the truth is going to be met with a lot of opposition there, bottom line. And the more truth you speak, the more opposition you will meet. Okay, because the truth is really not wanted in the nation of Guyana. It's just not wanted. Okay. It would be better for everyone if they had the truth. It would be better if people would listen to people like me when I say, hey, the opposition is cut off from the rest of the world. You can't lobby anyone. You can't do anybody because your leader is under indictment and under sanctions. And what's really sad about the whole situation is I saw a video where Azzuddin Mohammed was out publicly and he was saying he doesn't understand why the US government cares that he was sending gold from Guyana through the United States to Dubai, because he said that none of that gold was ever sold to the United States. So
as we analyze what's going on right here, as we try to suss out these situations, so we could get a good understanding, we were watching the actual proceedings, you know, over here at Delta 9 Media. We're going to present it and present it in a neutral manner. Janet is saying this: I was late. However, it appears that the defense is presenting its concerns about the claims of guilt of the Mohammed, despite the case is not completed. Big up yourself, Janet, and thanks for dropping those comments into the comment section. Big up to all the frequent flyers. Definitely, if you have anything to say about the headlines that was just highlighted in the court proceedings, or anything as it relates to what's going on with the present deliberations in the Caribbean Court of Justice as it relates to the extradition of the Mohammeds, one of which is the leader of the largest opposition party in one of the wealthiest nations in the world. Definitely feel free to call it in. The numbers on the screen, the banner is scrolling right now. Feel free to call it in as we stay in the discussion right now.
Or anyone in the United States, so it shouldn't matter that he was doing this. And I can understand his perspective if you're like someone, I don't know, like if I was like in high school or middle school or something, I can't explain it, but that's just not an adult perspective. Maybe that was a bad, I don't know. But the bottom line is this, guys. So he's been indicted on smuggling 10,000 kilos of gold out of Guyana. And according to the indictment, the gold was sent from Guyana to Miami, from Miami to Dubai. Okay. So the question is from him, from the video I saw, he wants to know, why does America care if he's just using Miami, the holding station, as a waypoint before he sends his gold on to Dubai? Because it really has nothing to do with America then. Well, it has everything to do with us. Because, you know, the question is, why doesn't he send his 10,000 kilos of smuggled gold to Cuba to go on to Dubai? Why doesn't he take his 10,000 kilos of smuggled gold to the Dominican Republic and then on Dubai? Why doesn't he take the 10,000 kilos of smuggled gold to Mexico City and then on to Dubai? Why doesn't he just go and have the gold go to Beijing and then to Dubai? There are so many places in the world his gold could go to. As a matter of fact, maybe he could find a way to get the gold from Guyana straight to Dubai somehow. I don't know. But why hasn't that been done? Why would he use Miami? Well,
wrap up in 5 minutes. We would appreciate it. Thank you.
Yes, please, Your Honor. Your Honor, I just wanted to point out that in relation to the question of waiver, and I believe it goes to some of the questions that the court would have asked at the beginning to Mr. Hussain. Your Honor, we first learned of the issuance of the ATP on the 31st of October when our clients were brought before the magistrate's court. We had no knowledge that the minister had intended to issue it or had even issued it. On that occasion, on the 31st of October, myself and Mr. Dujon, who's sitting at the table here with us, indicated to the court that we felt that the ATP was invalid on the ground of bias, and we had thereafter, at the commencement of those proceedings, we launched a request for referral to the magistrate, by the magistrate to the court, to the High Court, in relation to a number of constitutional issues. The magistrate refused those referral issues, and within 2 weeks of the referral, these proceedings were filed in the High Court. Your Honors, whilst the court has asked the question as to whether these issues could have been dovetailed and form part of the habeas corpus proceedings, Mr. Hussain did make a number of points, which I just wish to supplement quickly. First, we believe that at the basis of this case is a question of fundamental rights. We believe, even though that it is a judicial...
Do you really need to go over what Mr. Hussain said at such considerable length and upon which he was examined so closely, do you?
Your Honor, I'm just adding something, Your Honor, because the question...
So he missed out something. You go ahead then.
Yes, Your Honor. The question was raised as to whether we could have raised the question at the point of the habeas corpus proceedings, and that was my understanding of the question. we believe, Your Honor, that in that context, it would have been a fair response by the respondents to raise then the question of delay in relation to that issue. We would have been met with the question of delay. Secondly, Your Honor, in the Fuller case, the court specifically, the Privy Council specifically said that the question of bias and abuse of process are not questions to be ventilated in the magistrate's court. And in a slightly different context, the decision of the Court of Appeal of Belize in Leach, as I recall, the Court of Appeal of Belize indicated that the respondents to an extradition proceedings must be given every opportunity and at the first opportunity to raise challenges which goes to the proceedings. So I just wanted to condition and add our response to waiver and to the question as to whether it could have been deferred to a later stage, coupled with the fact, Your Honor, that this is clearly a rights case as its essence, and I wish to adopt the position of Justice Jamadar in the case.
I don't think, with respect, the judge had a position. I think he was asking a question.
No, I wish to adopt the Justice Jamadar's position in the case in which he articulated the position that in the context of Caribbean constitutional law and Caribbean judicial review, that it must have and bear effect in relation to the constitutional rights. So we believe that...
Counsel, when we lost you, you were making a point about necessity that I would like to ask you one question about. Would you mind, President, if I have that little question? In your submissions on necessity, you referred to a case, I missed it, but you said the point of it was that where the adjudicator had effectively set up, put himself or herself in the position of bias or compromise, that the doctrine of necessity would not apply. Did I understand you?
Yes, Your Honor.
All right. My question is, does that by parity of reasoning not work in the other direction as well? Here's what I mean. When your colleague was speaking, I raised the question of clean hands. We know that doctrine equity, he who comes to equity must come with clean hands. The question is, by parity of reasoning, is it possible to say that where a complainant of bias who says decision against me was biased, if that complainant is seen to not have clean hands, to have perhaps drawn the comment, can we really not use this reasoning to say, well, you are the one who waded into that pit. You can't really complain too much about it. Can you address that, please, quickly, and then, if you can, and we leave it at that.
Yes, Your Honor. Your Honor, the question of the conflict of interest, which the case sought to address, dealing with the question of necessity, deals with the conflict of interest in which the adjudicator would have found themselves in. The case does not contemplate such an expansive interpretation to permit the party who is complaining.
I was dealing with a parity of reasoning. Why does parity of reasoning not apply, apart from expansive?
I don't think so, Your Honor. I don't think so. Your Honor, just to wrap up, on the question of leave, I would say, Your Honor, that the court is well acquainted with the principles of special leave and the grant of special leave. We need to show that we have had a real prospect of success, which we believe we would have established in this case respectfully. We would have identified and relied on the case in our written submissions of Ramsahoy against Linden Mining Company, Mining Enterprises, which would have indicated the features which are necessary for the establishment of a special leave application. We believe that we would have satisfied almost all the criteria, the features explained or identified by Justice Barrow, which is well known to the court. Your Honors, this case is...
Mr. Ford, I hear you, and we have your written submissions.
Yes, sir.
I think you have spent the 5 minutes in the way you chose to spend it,
yes,
and
sir.
we really have to move on.
Thank you very much.
But on the issue of the standard to leave, we know the position because it is in your written submissions, and I assume you're not resigning from those positions.
Certainly not, sir.
Certainly not. Yes. Thank you, sir. Thank you very much indeed. Mr. Mendez, we come to you a little later than we had anticipated, but we are now with the first respondent, please.
Thank you very much, Your Honor. I hadn't intended to do so, but I think that given that the issues of waiver and necessity are fresh in all of our minds, that those are issues that would be convenient for me to deal with first, not only because they're shorter points, but also because either one of them, if decided as the first respondent has respectfully submitted, would be a complete answer to the applicant's case. As far as waiver is concerned, we have set our submissions on that point out in great detail in our written submissions at paragraphs 64 to 72, in which we set out in some detail the content of the letters written by the applicant's attorneys to the Minister of Home Affairs. And we say that those letters indicate that the applicants were engaging the minister as the minister responsible for extradition, the exercise of extradition functions. Clearly,
Mr. Mendez, if I may interrupt you, sorry.
Sorry.
Just trying to understand your submissions on this point, if you could help me. So is it your argument then, or submission, that the applicant should have brought some kind of preemptive application? So I've read your submissions with regard to the letters, the exchange of correspondence, but are you saying that there was some obligation on their part to bring some kind of litigation to preclude the minister from dealing with this?
No, that's not what we are submitting. What we are submitting is that by those letters, they engage the minister in the first respect to ask the minister to use her good offices effectively to ensure that there would be a peaceful, as it were, surrender to any warrant that might be issued as a consequence of the commencement of extradition proceedings. And in relation to the second letter, that is the letter from Mr. Hughes, as the second applicant has said in his affidavit, what they were doing in that letter was engaging the minister on the Katruni issue. That is to say, on the issue as to whether Guyana, as opposed to the United States, was the proper forum for the airing of these allegations made against them. So they say, this is what the second applicant said. He said in his affidavit that they were engaging the minister as the minister who had the power to issue the ATP on that question. And we respectfully submit that having engaged the minister in her capacity as the extradition minister, they waive their right later on to say, well, you can't make any decision in relation to the ATP because you are infected by bias. So we don't say that they should have brought proceedings. We are saying...
So, Mr. Mendez, can I ask you
even,
a slightly more fundamental question on that? Is it that in instances of bias, that waiver has the same sort of effect, or is it that in where there are allegations of bias because of, well, I'm not going to rehearse with you why that is important for procedural justice, etc., etc. that this question of waiver must be looked at a little differently. Would you say that there's any nuance around waiver when bias is at stake?
The submission that we are making is on the assumption that the rule against bias would otherwise apply. In other words, the assumption of our argument is that the minister is compromised by bias, either because there's automatic disqualification or because the Mercer test, let us call it that, would be applicable and would result in a decision that the decision is vitiated by bias. The waiver argument runs very simply this way, that if you have a problem with a decision maker on the grounds of bias, then you have to take the point with the minister. If you don't take the point, then you will be taken to have waived the bias, and you cannot raise it later on. That is essentially the principle of law that is stated very clearly in the authorities.
You
So
seem
this
to
is
be
what I'm
going
saying.
further, Mr. Mendes.
I'm sorry. Your Honor?
You seem to be going further by suggesting that the applicants actually invited the minister to make a decision in their favor in relation to this application.
Exactly. So that the point is, the normal way this would operate is that you are before a decision maker in some proceedings, and you are aware of the ground of bias. You could take the point, but you don't do it and allow the decision maker to go ahead. In this instance, what they are saying is they engage the minister, and according to their own affidavit evidence, matter of fact, they were complaining that the minister did not make a decision on the controlling factor. So that they engage the minister, knowing full well all of the facts that would give rise to this particular challenge. They knew the facts because, of course, they've now recited them in their affidavits, and they're all facts which predated the exercise of the power of the minister to issue the ATP. So that if I noticed that my learned friend, Mr. Ford, has not said or has not challenged that aspect of our case. What he has said is, or I should say, the only thing that he said that he did not know about was the advice given by the Attorney General to the Minister of Home Affairs. So leaving that part of it out of consideration for the moment, he does not appear to resist the submission that we make, that you engage the minister, you engage that minister because it is well known, and this is the evidence of the minister herself, which was not contested at all. It is well known that the Minister of Home Affairs is the minister who is dealing with extradition matters. The premise of the letters, and indeed the caption of the second letter, is request for extradition of the applicants. It is stated there. So all of these letters are being written in the context of an expected request that is going to the Minister of Home Affairs. And of course, they must be taken to have known, my learned friend protestations to the contrary, that she would be called upon at some point in time to exercise the power to issue the ATP. Yet still they are engaging her.
Mr. Mendes, I want to be clear on the timeline. I think you may have alluded to it, but let us be clear about that for the record. Yes. At what point?
This is
relative to the issuance of the ATP.
Yes.
At what point did you say these communications with the minister were made, which you are now saying amount to waiver?
The first is the letter dated the 6th of October 2025, and the minister's ATP is issued on the 31st of October 2025. The second letter is on the 13th of October 2025, so it's about two to 3 weeks before the minister issues the ATP. But as I said, it's all in the context of what appeared to be common knowledge that a request was in the works.
Thank you.
Now, to to the extent that my learned friend's answer to this point is, well, we did not know that the Attorney General had given advice. Our respectful submission is, as the Court of Appeal held, and we respectfully say the Court of Appeal was right in this regard, that the Attorney General's participation on the facts was to provide the Minister of Home Affairs with the decision of the Court of Appeal in the King case. And as the Minister says, she had sought his advice on the question of the existence of the arrangement with regard to extradition to third countries by the United States, and he provided her with the authority in King, which clearly said that that was already provided for. And the second thing that he has assisted her on is the filling out of the form itself for extradition. And it is important, I'll eventually take you to that, but the form is a very simple form, and you will see it attached to the Act itself at electronic page number 3308. And it is a form, and it is addressed to the worship, and there are about 4 blanks to be filled in. One of the blanks is the date. The first blank is, it reads, a request having been made to the minister by on behalf of blank, and obviously what you insert there is the United States, for the return to that country territory of AB. So you have to insert the name of the person who is requested, who is accused or alleged to be lawfully at large. Well, you have to strike out alleged to be unlawfully at large, because this is one of being accused of the offense of blank against the law of blank. So obviously you have to put in there what is the offense that the person is accused of against the law of the United States. So that is basically what the assistance that the Attorney General gave to fill in that form.
Mr. Mendez, that sounds very clerical. What kind of advice could the minister give, would need to give on things like your name and the country? In other words, presumably the minister could have advised or might have been asked to advise on factors beyond that as to whether her own discretion under 12 was satisfied. In other words, you're saying it's confined to this form and this other point, but the form itself, I'm wondering, being so basic, why would a minister need to be advised on this?
Your Honor, I am addressing the evidence that has been led by the applicants, and the evidence that they led. Well, first of all, the minister herself said that she received advice from the Attorney General in relation to the third party point, third country point, if I may call it that. But they relied on a newspaper report in which they quote the Attorney General as saying that he has assisted her in filling out the form. So the evidence that we have of the Attorney General's participation is the minister's evidence that he assisted her on the third country point, and their evidence that he assisted her in filling out the form. So as far as his participation is concerned, that is the evidence that we have. And as I said, I'm respectfully saying that those two bits of assistance could not possibly, and respectfully ask you to uphold the Court of Appeals decision in this regard, would not be sufficient to taint the minister's decision in any event. But we say, as far as what is said about the minister herself, we respectfully submit that, which I think your honors have already noted, has nothing to do with anything in particular that she did or said, but has to do with what other persons in the government had said about the applicants beforehand. That is the basis of their complaint, that she would not have been able to determine the issues fairly. We say that was waived. And my learned friend's answer to that is, well, the Attorney General participated and we did not know. We say that if there is waiver, then that is not sufficient to undo the waiver, as it were.
Sorry, could you pause for one brief second, please, Mr. Mendez? And get him moving on, perhaps. And may I inquire as to whether the Honorable Attorney General is in court?
I think
Yes, Your Honor, I'm here.
Well, I would very much like to see you, please, Mr. Attorney General. Would you mind turning on your camera, sir?
President?
I think my
Is there a
camera is
problem?
on.
President, there are
Yes.
two screens. So he's on the second screen. So if you want to see him,
Oh,
you will have
oh,
to
I
go.
see.
Yes. So himself and Mr. Gusai and I think one of the appellants and others are on that screen. So he's there, President. We are seeing him from our end.
Yes, but I apologize, Mr. Attorney General. I saw another screen here which I thought was you, but there you are. There you are.
Thank you.
Wonderful.
Thank you very much for observing my absence.
I absolutely. I want to
Missing
make
me
sure
at
that
the-
you're, I'm seeing you.
Thank
Very
you.
well. My apologies,
very
Mr.
much, sir.
Mendes. Yes.
Thank you very much, Your Honor. The second point that I wish to address, which I respectfully submit would be a complete answer to the claim, is the necessity point. I don't think that we are in dispute on the test itself. It is the application of that test. I understand my learned friends to be saying, well, necessity does not apply because the minister is not the only person who could have taken the decision, that decision could have been taken by someone else. Now, if I may make the point, first of all, that as we were at pains to point out in our written submissions, the extradition function of complying with international obligations is a quintessential executive function. We have pointed you to authorities in which it has been, the importance of that function has been highlighted because it involves the task of ensuring that Guyana's international obligations to its treaty partners are complied with, that Guyana ensures that our treaty partners are acting in good faith and making their requests in good faith and so on. In other words, there is a high political element involved in acceding to a request. And as I will point out to you when I take you to the provisions of the Fugitive Offenders Act, even in deciding...
Mr. Mendes, you must mean commencing the extradition process.
As well,
because you cannot have an extradition process without the judicial determination on it. Is that correct?
No, the extradition process commences with the issuance of the ATP.
Exactly, eating the ATP, that's what you mean, okay.
I mean that, but as well, the issuance of the eventual order of extradition, if you get to that stage after the judicial process, is also an exercise of political will.
After the magistrate has said, go ahead.
That's correct. Even if the magistrate says go ahead, even if the High Court says go ahead, the Court of Appeal, the CCJ, the minister still has the discretion not to order extradition.
Yeah, but if the courts say no to the extradition, that's the end of it.
But that's the end of it, yes, of course.
Thank you.
The minister has no discretion if the court says that, for example, that there's no extradition crime established. But the point I'm making is that the minister has a discretion at the ATP stage as well, because when I take you to section 12.1, you will see that it says that the minister may issue an authority to proceed in Form 1, which suggests that the minister has a discretion not to issue it. Because it could happen, I'm not suggesting that in this case, it was something that was a candidate for other consideration, but it could happen that a request is made by a treaty territory, but for some reason the government of Guyana is of the view that this request should not be entertained at all because of whatever else may be taking place on the international stage between Guyana and that particular country. There may be many other political reasons why Guyana may decide not to accede to a extradition request at all, and therefore, in the minister's discretion, decide not to issue it. My point is, therefore,
I know this is not central at all to the discussion, but if the minister is satisfied that the conditions set out in the statute have been fulfilled, would the minister not come under an international obligation to issue the ATP? And if that issuance does not take place, will that not represent a potential breach of the treaty arrangements? But are you then saying that this court would not have jurisdiction to inquire into that breach?
That would be not for this court, but the point is that would exist at the international law level. But the point is that the fact that the legislation gives the minister the discretion whether to issue the authority to proceed indicates that maybe exceptionally that the minister could decide not to issue it at all. My point is that there is a political element in both the issuance of the ATP and in the issuance of the ultimate order for extradition. And this is why the legislature has made the choice of vesting in the minister the power to exercise the extradition functions, and not, for example, in the director of public prosecutions, and not, for example, in the permanent secretary of the Ministry of Foreign Affairs or some other functionary of that sort. It clearly is important and is consistent with extradition law and consistent with the need to ensure that we comply with our international obligations, that it is a minister, a member of the executive, a member of the cabinet that is vested with the extradition functions.
Now, you say there's an overlap between that argument and the issue of delegation?
That is correct. So the point is that whereas my learned friend is urging upon you that the minister could have exercised the power under the Interpretation and General Clauses Act to delegate to a public officer, respectfully, that would run contrary to the intention of the Fugitive Offenders Act. It runs contrary to the intention of the legislature investing that power in a minister. Because that decision...
Can we just pause a little bit? So let's suppose you are right on that. Is it then part of your argument that the only minister is the Minister of Home Affairs? Or is it that... Oh, so I'm sort of adopting your not conceded, but for argument's sake, acceptance that there is infection through bias. Let's suppose that is the status quo.
Yes.
And let us take your point that under 27 is not applicable, and the intention is, because of everything you've just said, the political executive function, it must be a minister. If, and I know you're not conceding this, if the Minister of Home Affairs was in fact clearly infected by bias, actual or otherwise, what would be the result, given your construction of 12, i.e. that it is only the minister who could exercise this power?
If it is only the minister, then the minister has no choice but to exercise it. And the fact that the minister is apparently biased is of no moment.
All right. Suppose the minister was actually biased. Suppose there is, because you could have both, you could have actual bias too. Suppose there was evidence, clear evidence of the minister having some sort of pecuniary or other interest in the outcome, however that evidence came out. Would your position be the same?
Okay, if I may use this example, let us assume that the person who the United States wishes to have extradited is the minister's child. In those circumstances, obviously, all of the arguments that we have presented as to the modification of the rule against bias would be very difficult to make. So what ought to happen in these circumstances is that the president ought to relieve the minister of the extradition functions temporarily and vest that portfolio in another minister. And that
way you preserve the impartiality for the decision maker, because okay, so that I understand clearly what you're saying, so that the portfolio remains the determinative consideration as to which minister, but the infection by bias is cured not by delegation to a public officer pursuant to 27, but by the removal of the portfolio from the person affected to another person.
Exactly.
Yeah, no, okay, fair enough. But you will say that is not a delegation then.
If I may, Peter,
sorry.
It does not have to be by the shift in portfolio, but by the appointment of another member of cabinet, another minister, to act as Minister of Home Affairs for a limited period, etc., to execute those functions. So the portfolio remains with the Ministry of Home Affairs, but a different person is acting as the minister. Thank you.
Yes, Your Honor.
So Mr. Mendez, if I may, just quickly. So in Froome, where the applicants submitted in Froome, it was delegated to a lawyer. And as I understand you, you're saying that under the FOA in Guyana, that would be contrary to the scheme of the legislation. In Canada, that's because of a different legislative scheme. Is that it?
I don't know the answer to that question because I don't know the legislative scheme that was being operated in that case. But what I am saying is that the legislative choice in Guyana is clearly that the power be exercised by a minister, and I've given the reason why I think that is proper legislative policy, and therefore why it is that it would be an improper exercise of the power of delegation to delegate it to a public officer, because that public officer would not is not a member of the executive and therefore would not be able to exercise the political judgment that would be necessary in those circumstances. But the point that I'm making is that even though in the case that we have imagined, that is to say that the minister is being called upon to issue an ATP in relation to her son or her daughter, as the case may be, even though you could imagine that you solve the problem in either of the ways just suggested, in this case, that's not a solution, because the basis of the applicant's complaint is that any member of the executive would be infected. That's the argument. The argument is that anybody would be, of course, as they say, beholden to the president and the vice president and the attorney general who have made all these statements. So there could be no minister who could be appointed, who would be now a member of the government, who would not be subject to the same complaint. And we respectfully submit that, having regard to the fact that nothing is alleged against this minister, except that she ridiculed the second applicant, not even the first. Nothing is said about her in relation to the first applicant. The only complaint is made in relation to the second applicant, and it is about what one would expect would happen in any political campaign. Respectfully, according to their own case, they ought not to get any relief, in other words, even if bias is established in relation to this particular minister. And that's our application of this.
That's the easy case.
That's the easy case.
Yes. What if, again, hypothetically, one of the three top officials against whom allegations of, shall we say, intemperate statements were made, was in fact the Minister of Home Affairs? How would you approach that issue?
That would be, that is to say, as to whether again, don't forget, Your Honor, at this stage of my argument, the assumption is that bias is established.
Yes, no. We understand you fully. And obviously, you do not concede that. Right. Mm-hmm.
But on the assumption that bias is established, then
yes.
the two solutions that we have just found cannot be
used. Exactly.
Can't be used at all.
Right.
So that you're stuck with the minister to whom the extradition portfolio is assigned, exercising the power, because that is the only minister, or put it this way, it is only ministers to whom the extradition portfolio is assigned who can exercise the power, but all of them are compromised in accordance with the arguments.
So ex hypothesi then, how is that problem to be resolved? Because on the hypothesis, which none of us, of course, is asserting, that there was this systemic bias, how is that to be resolved consistent with the rule of law?
Consistent with the rule of law, since seeing that somebody has to make the decision, and the only persons who can make that decision by law are compromised, then the decision just simply has to be made. In other words, Your Honor, we have to hold our nose and proceed.
I thought you'd have said that the court ultimately could superintend whether the conditions would have been satisfied.
But that would be done in any event.
Right.
So we're just dealing with the problem of bias by itself. But the point is, and I'll come on to that when I'm dealing with the nature of the function that is being exercised and interrogating exactly the extent to which the rule of bias can apply. But the fact of the matter is that the merits of the complaint, that is to say, whether the extradition is actually unlawful or would not in fact be made, that will be interrogated by the magistrate. That will be interrogated by the High Court and the Court of Appeal and the CCJ. So there's all the protection, the rule of law protections that you're referring to, Your Honor. All of that will be canvassed before judicial officers.
So that's why you contend then that the issue of bias and the litigation of that issue is misplaced in relation to the minister.
That's
because
correct.
Even in a situation where you concede that there was in fact bias, that would not halt the proceedings. They would proceed to the second stage of the judicial hearing. Do I have you right?
Yes, and of course there are many points that I make. There's also a great degree of artificiality about this complaint because my learned friends have not yet said, despite the fact that the court this morning has asked on a number of occasions, they have not said what is unlawful about the extradition. They have not said what factor are they pointing to which would suggest that there would not be an extradition.
They're pointing to the fact, allegedly, of bias. And what they are saying, if I understand it correctly, is that the mere presence of bias is sufficient in and of itself to nullify the process undertaken by the minister who is infected by bias.
Yes, Your Honor, but I was responding to your point that the substantive issues of legality will be addressed at the judicial phase. And I'm saying that even as we now stand, even though obviously that is so, that any question of unlawfulness can be addressed at the judicial phase, they have not, despite questions from the court, identified any particular issue that the minister may have decided differently. In other words, they have not suggested, for example, that the extradition is being pursued for political reasons, or that or that any of the applicants will be prejudiced on the basis of their race or religion or politics. They haven't suggested that. Or that there is no specialty arrangement, or that this is not an extradition crime. They have not made these submissions at all.
Mr.
Nothing
Mendes,
has been suggested.
we get you on that. I want to return you to a point you made earlier. You said
Yes.
that extradition, or rather the ATP, is quintessentially an executive act, and
Yes.
it needs to be seen to have been done by a minister. Question to you would be, minister goes on holiday, the minister is sick. Who
Yes.
acts for the minister in the meantime?
Well, there would be provisions under the Constitution for other persons acting for the minister. So in the meantime, somebody would have been appointed by the president to act in place of the minister.
It need not be another minister. It can be a permanent secretary. Is that correct?
I can't remember the exact. The Constitution does speak to who can act for a minister. I don't recall exactly at the moment.
I think off the top of my head, Mr. Mendes, it has to be another minister.
Fair enough.
It might be a parliament. It might be a parliamentary secretary.
Okay.
I'm trying to remember.
No.
Yeah.
So we're not. Let's not get lost on that. What I'm getting at is this: you say that the matter requires political judgment, and it is only the minister that can bring that. My question is, why is it that a permanent secretary cannot bring political judgment to bear on a question like this? A permanent secretary.
I think your answer, Mr. Mendes, will be because the permanent secretary will not sit in cabinet and will not be answerable, and the collective responsibility will not appertain to what the permanent secretary does.
That's precisely what I was going to say. I was going to say the permanent secretary is not a member of cabinet, and therefore will not be, first of all, would not be aware of, or not, maybe might be aware of, but certainly not sitting in cabinet and participating in any discussions concerning government policy or the current relationship between Guyana and the requesting state. And
so that submission must mean that section 26 sub 2 and section 27 of the Interpretation General Clauses Act cannot operate where the minister is a person pointed to in a piece of legislation to perform an act. Do you go that far?
No, I don't go that far. But what I'm saying is that just like every statutory power, it is subject to public law constraints. And whereas in relation to some other statutory powers, say the power to issue licenses, there would not necessarily be any constraint on the minister in delegating that power, say, to a permanent secretary. In the area of extradition and international relations, there is the constraint, I am respectfully submitting, on the exercise of the minister's power to delegate that power to someone who is not sitting in cabinet and therefore is not accountable to Parliament. And this is why I'm saying ultimately, therefore, on the applicant's submission, all ministers are compromised, and therefore there's no minister who can exercise the extradition function in the context where it would be not appropriate to delegate the extradition functions to somebody outside of the executive government.
Mr. Mendes, I understand that very clearly. I just want to get something, maybe it's sort of like to summarize what I think I hear you saying. Conceptually then, barring everybody being infected, that argument,
yes,
if there is sufficient bias in the relevant minister, then the appropriate thing to do to protect the rule of law would be to take that portfolio and pass it on, whether to another minister or appoint a person to act as our brother has suggested. Would you agree that in that hypothetical, that would have been the due process to balance the international obligations, keep it with an executive member, purify the system by removing the infected person, and you achieve that by moving it so that conceptually bias remains a relevant consideration that can be cured through the mechanism that you have proposed. Is that a fair summary of what you've said?
Absolutely, of course, but in case my learned friends jump on what they perceive to be a concession, I'm saying the assumption is
I know, I'm very clear.
Bias applies.
I am very clear that you have not conceded that. I'm not for a moment trying to put words in your mouth, please.
No, I know.
I am. That's why I said on the hypothetical. I'm very clear what your position is on that. I'm just trying to understand it. Thank you.
Yes, that would be the normal. That would be the normal consequence of a finding of bias.
Yeah.
That would not that somebody else who is not infected by bias would exercise the statutory function.
But in a case, as you have said before, where everybody is infected, on the hypothesis, of course, then the minister has to do what the minister has to do. In that latter case, is the question of bias reviewable by the court, or clearly it follows from what you have just said that that is not a question for the review of the court?
Well, as long as you find that there is necessity, necessity doesn't prevent the court from reviewing and making a determination as to whether the apparent bias test has been satisfied. What it means is that even if you find that it is satisfied, there is nothing that you can do because the law requires that this.
So what's the point of deciding if you can't do anything about it?
Well, the point is that
equity doesn't act in vain.
The point is, Your Honor, you may decide because the doctrine of necessity applies. You may decide, well, I won't waste my time to make a determination on bias because in any event it would make no difference.
Right.
But I'm just saying, I'm answering your question.
No, sorry, I wanted
decide.
to follow up with that. Okay, so in a sense, then the reviewability of the bias question might not bear fruit, might not be useful. What about the provision in 12.2, where the minister must be satisfied that certain things are done?
Big up to all the travelers that are in the chat right now. Swan Girl, thanks for dropping insightful commentary into the chat. Marcia, welcome into the live. Rasta Empress, our moderator, big up yourself and thanks for being a part of the live. Yanet, Delta 9. Well, actually, that's myself. I'm reading back. You could tell how fast I'm trying to go through this, right? I see the legal alien as well has touched down into the live. Big up to all the travelers as we continue to follow closely the details. Make sure that you thumbs up the live and share it if you haven't already so that persons will be updated with what's going on.
The person concerned could not lawfully be made. Now, let us assume that there is evidence that it did appear to the minister that an order for extradition could not lawfully be made. Let us assume that there is evidence, however that evidence comes about, but the minister said, you know something, this extradition cannot lawfully be made because section 8.2 or 3 or whatever of the act is not satisfied. And it appears to me that it is not satisfied, but nevertheless, I'm going to issue the ATP. In those circumstances, the minister would be acting contrary to section 12.2 because section 12.2 prohibits the issue of the ATP if it appears to the minister, etc., etc. So yes, obviously the issue of the ATP in those circumstances would be reviewable. The more difficult question is whether when the minister says, well, it does not appear to me that an order could not lawfully be made, but then you challenge it and evidence is produced that, well, one of these provisions of Section 8 was not satisfied because there is no treaty or there is no arrangement and so on. In other words, you're saying that it ought to have appeared to the minister, and therefore the minister made an irrational decision that it did not appear to her.
Mr. Mendez, isn't that the scenario?
So,
isn't that the matrix in 1 or 2? Isn't that the 1 or 2 matrix, basically? No, it wasn't raised that way, but in effect,
no.
That's the 1 or 2 matrix, right?
In effect, so, because it was the way the Trinidad and Tobago Act is framed. The minister had to be satisfied that there was an arrangement in place,
and there was
before
none.
So
on the 12.2 point, then the minister has to exercise a deliberate judgment, has to consider the relevant factors, including, of course, Section 12. Now,
yes,
where the minister decides on this over a 2-hour period, would you say that that represents sort of deliberate consideration of all the things the minister ought to consider before deciding on the ATP?
Well, Your Honor, I am not aware of evidence that the minister decided this over a tour. I saw that in my learned friend's submissions. I have not seen it in any of the evidence that is before the court. But
I'm
what
not sure it was rebutted that the request for the application, the request for the extradition came in on somewhere in October. And then a few hours later, the ATP was granted. Do you dispute that?
Your Honor, what I'm saying is that that appears in my learned friend's submissions. It does not appear in the evidence that is before the court, unless I'm mistaken and I have missed it somewhere. But in any event, Your Honors, what the minister did in her affidavit is to set out the process that she followed. Now, if it is now being said, well, she could not have followed that process because it only took her 2 hours, that is not the basis of challenge. The grounds of challenge is not that the minister did not properly perform her function under Section 2. The only ground of challenge is bias. So that
but even so, would your submissions on waiver be relevant to that point? In the sense that if it was a case that everyone was anticipating this extradition request to be made and counsel for the applicants had been communicating with the minister saying, we see this may be coming, when it comes, we will cooperate and all that stuff. I'm asking a question here, maybe I got it wrong, but would that be something to take into account as to whether the speed at which ATP was issued was unduly hasty?
Well, that would not affect the argument on waiver. That is
not that it affects the argument on waiver, but whether the argument on waiver which you made could have addressed that point.
Well, it wouldn't. Well, I don't think so, because if the argument, if the ground of challenge is that the minister did not in fact exercise the functions under Section 12.2, because the time was too short to do so, that's not a bias argument. That is an argument that the minister did not exercise the functions at all. And of course, that is a classic ground of public law challenge. You are required to exercise a discretion and you just simply didn't do it. But that doesn't, you can't, I'm sorry, Honor, that argument is not counteracted by waiver, because they're not waiving her exercising her power. They are waiving the challenge on the ground of bias.
Yeah, I understand that. That's a different question, but I'll leave it.
But the very short period of time, I suspect that the other side would argue, support their argument that there was some degree of bias there.
Well, Well, Your Honor, if
They
that
made,
was
in other words, the minister made her mind up, a long time ago to let the ATP be issued.
Well,
the
Your
question
Honor,
was, I mean,
if that was
the question was whether the conduct of the applicants might have played into the minister making up her mind that this is something that could go quickly, because the appellants may have signaled ahead of time that we're expecting this, so if it comes, you make it, we're ready to deal with it. Anyway, but we can leave it at that.
Your Honor, my point is a fundamental one, that it was not pleaded that the minister did not or could not have exercised a function properly under Section 12.2. If that had been an allegation, if it had been said that you could not have been done so because of the short period of time, then we would have taken instructions on that, and maybe the answer would have been, well, just as the appellants were aware that a request was in the making and so on, I began to prepare myself for a request because I knew it was coming.
I'm not sure about the strength of that argument at all, Mr. Mendez, because you can only respond once the request has come in. Would you know what the offenses are, for example, that the request related to?
Well, Your Honor, all I am saying is that we can't interrogate this issue at all.
No, well,
and it would not be proper for the court to interrogate the question of the failure of the minister to exercise her functions because of the 2-hour the 2-hour window, because that
pleaded.
was not pleaded.
Fair enough.
And I'm saying, and I'm emphasizing the importance of pleadings, because I'm speculating, obviously,
yes,
because I do not know what would have happened if it had been pleaded, but I'm speculating that the minister may have said that I was readying myself for the request. And
well,
to answer your point,
as you say, maybe we should be cautious about going down that road. I think our sister, Justice Anani, who wanted to ask a question, please.
Thank you, President. Mr. Mendez, if we could go back to the nature of the statutory function under Section 12.
Yes, I'm coming to that.
I'm very interested in that because I think all parties have agreed that that's quite important to assessing what the requirements of procedural fairness would be in the circumstances of this case.
Yes.
The applicants have argued that the nature of the function of the minister is adjudicative. And they indicated that even though this is clearly not an inter-party setting, it could still be an adjudicative function. Now, there has been a lot of emphasis on Section 12.2, which places a very specific duty on the minister, but in particular circumstances. That's if it appears to the minister that an order for the extradition of the person concerned could not lawfully made or would not in fact be made. In those circumstances, the minister has a duty not to issue the ATP. My question is this: is there a responsibility, a duty on the minister once a request is received to make any kind of positive determination that an extradition order can lawfully be made and would in fact be lawfully made? Is that a responsibility that Section 12 places? I'm asking this question because I see quite a distinct difference between a duty not to issue the order if certain information is before you, as opposed to a positive duty once you receive a request to make a certain type of determination. I have a follow-up question. Thanks. Once you answer that, please.
Yes, Your Honor. My answer, the short answer is yes. There is no positive duty to make a finding of lawfulness, or that an extradition order would be made. And in fact, that is the case that we have put forward in our written submissions. But it requires both an examination of the language that is used in Section 12.2, but it also requires interrogation of the type of the circumstances in which extradition might be unlawful, and therefore an interrogation of what process the Minister of Home Affairs would be expected to follow in complying with Section 12.2. So I'm indicating that I have to answer the question in two stages. First, by looking at the language, and then by imagining the types of situation that might appear before the minister. So the section says the minister shall not issue an authority to proceed, and therefore that's the duty. Do not do it. When, and it answers that question, if it appears to the minister that an order for extradition could not lawfully be made or would not in fact be made. So that the minister has to ask the question of herself, does it appear to me that an order for the extradition of the person concerned could not lawfully be made or would not in fact be made? Now the minister could say, presumably, well, I'm not aware of anything that makes it appear to me that it's unlawful, and that's it. And you sign off, you sign the ATP. Nobody has presented anything to me. And then the complaint might be, well, you just can't sit down and say, well, it doesn't appear to me, and therefore I am going to issue it. The prohibition is not there. The valid complaint would be made. Well, you have to do some sort of inquiry. You can't just sit down on your desk and say, well, nothing has come to me to make any of these suggestions, and therefore I will do nothing. And therefore there's no prohibition, I will proceed. So it does require some sort of inquiry by the minister as to whether there are any circumstances presented by the documents that are before her, which might make it appear to her that the extradition could not lawfully be made. So that's why I say, let's look at the examples now.
Before, just pause, and nuance. Yes. You said they must look, so that you say it does require some sort of inquiry by the minister.
Yes.
But then you qualify that by saying the minister must look at the documents placed before them.
Well, that's the first thing.
Before you move on, is it that is a limitation of the inquiry to look at the documents presented?
Not necessarily. It all depends on the case.
No, fair enough. I just wanted to be clear because you qualified the statement by saying by looking at the documents. I just want to be very clear because I assume you will tell us what is the sort of standard for the quote-unquote sort of inquiry.
Yes, but the point is, Your Honor, that it all depends upon the case. And I have to remind Your Honors that this exercise is taking place in circumstances where either a provisional warrant has already been issued before the request is made, and somebody is therefore in custody, maybe on bail, but certainly in custody, and therefore the minister has to decide. You can't take your time about it. You have to be mindful of the fact that somebody is in custody and a request has not yet been made, or an ATP issued, or the exercise is being performed at a point in time where there is no provisional warrant, but there may be concern that the person might hear about the request and flee Guyana and put themselves beyond extradition. So I'm saying that there is some constraints of time as far as the exercise of this power. So that will obviously impact upon the degree of investigation that the legislature would expect the minister to engage in. So against that backdrop, the first section 8.1 says, a person shall not be extradited under this act from Guyana to a Commonwealth or territory, or could be committed to custody and so on, if it appears to the minister, to the magistrate, to the High Court, to the Court of Appeal, and so on. A, the offense of which the person is accused or has been convicted is an offense of a political character. Now, that obviously means that for the minister to say, does it appear to me that the extradition would be unlawful? You're going to have to look at the offense. And looking at the offense, which would be in the documents that the minister is provided with, because there's a requirement to provide particulars, etc., the minister would look at that and say, well, does that appear to me to be an offense of a political character. So the minister must ask that question. Then the next one, the request for extradition.
So I think we're following the logic of what you're saying.
Yes.
My sister said she had a follow-up question. I don't know if she still has it.
Thank you, President. What I've been trying to assess is whether the kind of examination which the applicants have argued is required under Section 12 actually arises given the nature of the responsibility placed on the minister. So, for instance, the applicants have argued that when deciding whether an ATP ought to be issued, a minister has to look at evidentiary compliance or sufficiency. The applicants have argued, for instance, that the minister has to make an assessment as to whether there would be any discretionary bars against unjust or oppressive extradition, and the Catroni factors. What I'm just trying to make sense of is whether under Section 12, whenever a request comes in, the minister is required to make a positive determination about all of these matters.
Yes,
that's a very different kind of responsibility than.
Yes, I know. I'm submitting no, because what I'm doing that by way of the examples. When the minister says, I looked at this and it does not appear to me that the offense is of a political character, the minister does not determine that the offense is not of a political character. And similar, when it says the request for extradition is in fact made for the purpose of prosecuting or punishing him on account of his race, tribe, sex, religion, and so on, the minister would be looking at the material and saying, it does not appear to me that that is the actual purpose of it, but it does not mean that she's saying that is not the purpose, because later on evidence may be presented by the applicant when they have the opportunity before the magistrate or the high court of adducing evidence that this is really for the purpose of prosecuting me because of my race, nationality, or political opinions, and so on and so on.
So, Mr. Mendes, my last question on this, just to be clear based on your submissions, is that can bias arise if the nature of the statutory function is not adjudicative in character? It's a basic question I'm asking.
Yes, and that is basically our submission. Our submission is that we accept the general proposition as we must, because that this is what the authorities say, that there's an obligation of fairness attaching to every statutory power, every statutory duty. The question is, what is the content of fairness? And that would depend upon the nature of the function and the statutory and factual context in which the power is to be exercised. And one of the factors which the authorities have indicate, and the learned friends cannot dispute it, there are so many authorities that say it, one of the important questions is whether you are adjudicating on anything. And we are respectfully saying that the minister does not adjudicate in the sense of make a determination of any of these things. All the minister is saying is, I have done the examination that I am duty bound to do under Section 2 to determine whether I am prohibited from issuing the ATP. And all I am able to say at this stage, and in fact, that when you look at the minister's evidence, that's what she says, all I am able to do at this stage is say, nothing has come before me which would suggest that any of these prohibitions apply. And as a matter of fact, she says, maybe that evidence might be presented later on, but it has not yet been presented to me. So I am unable to say that it appears to me that it would be unlawful. And to the second part of your question, and this is the Section 8 would address the question whether it appears to her that it could not lawfully be made. But the second question is whether it would not in fact be made, and that requires the minister to engage in some speculation as to whether the High Court, in exercising its power under Section 17, That is to say, to decide, because under Section 17.2, the High Court may order a person to be discharged if the court is satisfied by reason of the trivial nature, etc., and that would include the Cotroni principles, that having regard to all of the circumstances would be unjust or oppressive to extradite him. So it is possible for the minister, to say, well, it appears to me that it could not lawfully be made, sorry, it would not be made, as opposed to could not lawfully made, that it would not be made because there are these factors that are pointing so compellingly in the direction of it being unjust and oppressive to extradite that it appears to me that it would not lawfully be made. One of those possibly later on down the road is the Cotroni factors, but the Cotroni factors require a lot of evidence to be put before the court. And again, the ministers pointed this out. A lot of evidence to be put before the court concerning who started the investigation.
Mr. Mendez, I think we are, so, but
thank you very much.
I think I think part of what you have explained is, and again, I'm seeking your feedback as to whether my understanding of what you're saying is fair. That is my understanding. This is not a rubber stamping of or ticking of boxes of receipt of documentation. Even though you frame it in the negative, what is required of the minister goes beyond that. You say it is not adjudicated. Fine. I'm not on the labeling for the moment. I'm on the actual exercise of what has to be done. More is involved than simply rubber stamping. This is not a clerical function the minister is exercising. This is an executive, discretionary decision within the limitations of what you have described. Is that a fair? Sorry, is that a fair summary?
Sorry, before you answer, I invite you to answer, but could you, in answering, also wrap up? You've gone well over the hour assigned. So having answered my brother, if there's any specific point you need to make beyond what's in your written submissions, please do, and we're going to move on. Thanks.
Thank you very much, Your Honor. Could I claim some extra time for injury? Injury time?
You have been given extra time.
I'm just my learned friends have been given a lot of injury time because there's an important point that I wanted to make.
Please.
I'll answer Justice Jamada's point very briefly. I'm saying that there's no determination that is made by the minister. And in that sense, there is no adjudication. But I am not saying that the minister has nothing to do. Obviously, the minister has to ask the question, does it appear to me that it could not lawfully be made, and that therefore requires some sort of examination. I'm just saying that in the absence of the applicant, that cannot be or cannot approximate what would happen, for example, when you go before the magistrate and the magistrate has to answer the same questions, or when you go before the High Court and the High Court has to answer the same question, and therefore that must impact upon the content of the rule against bias. But most importantly, and this is the point that we make, and if I may spend the remaining time just dealing with this point, Mr. President, most importantly, is the statutory context in which this decision is being made. And the most important part of this, which I've spent a lot of time in our written submissions emphasizing, is that the legislature has decided that it is the minister assigned the extradition portfolio who is to make these decisions. And the minister, therefore, the legislature must have anticipated that the minister at some point in time will have to be entertaining requests for extradition, both in relation to political opponents as well as political friends. And this is an important part of it, because if a political friend comes before the minister, the United States or whichever country is seeking the extradition of a political friend, the same accusation of bias can be made. In other words, that the minister's the ministers, there's a real possibility that the minister may unfavorably or favorably view the case of this particular person because they're a political friend and the opposite in relation to a political foe. My point is that the legislature must have contemplated that the minister, being a political appointee, would have to face political foes or political friends. And it would um, uh, undermine the legislative choice that is made if you were to say, well, you have to step down, and all ministers will of course be excluded on this argument, and somebody else would have to be appointed. When the legislature must have anticipated these possibilities, and this is why we say, in circumstances like this, the test is whether you had an open mind and whether you actually performed your function in a genuine way. That would be the test in these circumstances.
But Mr. Manders, just quickly to test the hypothetical. It's the minister and the minister's child. The minister's child is also whatever. And the application to extradite goes to the minister's child.
Yes.
Won't the same principle that we agreed on earlier apply?
No,
you talk about opponent and friends.
No, Your Honor, because
Why
again, because when you appoint a minister, you know that the minister has political friends. You know that the minister will have run a political campaign. You know the minister may have said things that are not nice about political opponents, and in circumstances where your political opponents are accused of crimes, and it is public, as in this case.
My hypothetical is where the political friend is a child.
Yes, but Your Honor, I'm saying that when the legislature is making the legislative choice to give the power to the minister, it would not have in contemplation the unusual circumstance of the minister's child being the subject of a request. But the legislature would have in mind the usual circumstance of the minister having political opponents that the minister may have said, although that's not the accusation in this case, may have said very unkind things about the political opponents, may even have alerted the electorate to the fact that there were accusations of criminal activity against your opponent and so on. Those are the things that the legislature would expect the minister.
And do you think there is a threat? Do you think there's a threshold apart from general accusations of criminality and so on? If the allegation was specifically that I know that this third-party state intends to extradite, and when that comes, I am going to grant it. So okay, so you have a corpus of general, whatever. If it is specific now to pre-knowledge or pre-statements about the possibility of extradition, and statements that say when that comes, I am going to extradite because these people are A, B, C, D, E, F, G. Does that make a difference in this this construct you have about the legislature presumed both political opponents and friends, and so even where the political opponent or friend, whoever, now the evidence is specifically in relation to the extradition process. Does that make a difference?
Well, again, that is catered for in the test that we say should apply, whether you have an open mind and whether you are performing your functions genuinely. So the question would be whether the minister had an open mind.
An open mind there means what? What does that open mind mean? If you pre-stated that I hear the extradition and if it comes, I'm going to grant it, is that an open mind?
But if the minister had said that?
Yes.
Well, first of all, again, the question whether you have an open mind is always fact specific, as you know. And just simply because you said something that suggested that this is how it would happen, The authorities are replete with circumstances in which the court said, even though you expressed yourself in this way, that does not mean that you have an open mind. But if the facts are such, that it establishes very clearly that you do not have an open mind, that come what may, no matter what is presented to me, I am going to exercise my power in this way, then that is not what is in contemplation by the legislature.
Is that, Mr. Mendes, is that the test in Porter and McGill?
No, it is not. But it's the test that it is the test that we are respectfully submitting. That would be the appropriate test to be applied in the circumstances of this case. Justice Jamada, if I may give you an example.
Sorry, it's going to be a very short example, please. We have well past injury time.
Your Honor, would it be okay if I steal some of the Honorable Attorney General's time if he gives me? I just need to complete this point. It's very important to my case.
Honorable Attorney General?
If he can give me 15 minutes, if he doesn't mind.
Yes, I'll give you 15.
You'll see it? Okay, good.
I'm grateful. I'm very grateful. If I may, Justice Jam, if I give this example, let us assume that just like the minister having to deal with a request in relation to her son, let us assume the particular political opponent is somebody in respect of which there is personal circumstances that leads to hostility or enmity or whatever. Let's assume that they are in some other personal dispute. It could be financial dispute, it could be personal, romantic, something of that sort. I don't want to be too creative, but just in other words, this is going beyond, it is a dispute that goes beyond what you would normally expect of political opponents. So this is personal between the minister and this particular person. Then that is different. That is not within the contemplation of the legislature.
And
what's
in
the
that
consequence
context,
of that?
what would be your remedy?
What would the consequence of that be?
Yeah. What will,
In those circumstances, the consequence is, as we have suggested before, the president appointing somebody to act in the stead of the minister, or assigning the responsibility temporarily to somebody else.
And if the president does not do that, what then?
Then you're back in the situation where there'll be the normal remedies that are available to the court. If waiver applies, of course, it doesn't apply. If necessity applies, of course.
Including quashing the ATP.
Including the quashing of the ATP.
Okay.
Those are the normal remedies.
But Mr. Mendes, it will never be an abuse of process under GR to bring the challenge then. The takeaway as you come to the end seems to me to be, subject to proofs and standards, you can bring a challenge on bias. At this stage, whether it succeeds or not is a question of standards, that is which test you apply, the Porter and McGill or the open mind test, and the proofs, the evidence. Is there any evidence that this minister did or that what the AG did that impacted could have any significance? But conceptually, you could bring it.
Well, Your Honor, I'm a bit surprised that I'm being asked that question because we have never challenged the jurisdiction of the court. And as a matter of fact, in our reply to my learned friends, we have said that we do not say that the decision is not subject to judicial review. The question is on what grounds.
Yeah.
It is
point taken.
It is a very serious.
I think I'm influenced a little bit more by what I may have read in the Court of Appeal decision, but in fairness to you, you are right. So
yes.
No need to respond any further. Yeah.
Yes. So just to make the point that I'm making about the legislative intention and undermining the legislature, if I may draw your attention to the decision of the divisional court in the United Kingdom. This is the Goodyear Project and Runnymede Trust against the Prime Minister. It's a 2022 decision, and it's a decision of Justice of Appeal Singh, who I think sits on the Privy Council from time to time. And I'm looking at page, electronic page number 4885. And he said in relation to Justice Sedley's decision in Kirkstall, which is one of the cases that my learned friends relied on, he says, While he's referring to Justice Sedley, while he rejected any hard and fast distinction between administrative decision making and either judicial or quasi-judicial processes, he recognized that any attempt to apply the principles of apparent bias outside of the context of judicial or quasi-judicial decision making had to be sensitive to context. Justice Sedley accepted that when considering a planning decision, it was important to recognize that decision makers such as elected councillors or members of an urban development corporation might have legitimate prior interests. For example, they will come to their positions, elected or appointed, because of local knowledge. The principles of apparent bias could only operate in this context to the extent that any prior interest could be identified as legitimate. And a similar statement, and very important statement, is made by Justice Supinka in the Supreme Court of Canada decision of Old St. Boniface against Winnipeg, and I'm referring to electronic page number 873, where the court said, is therefore, again dealing with elected councillors, it is therefore necessary to examine all the factors under which a committee of council operates. I start with the most significant fact that the statute provides for a hearing before a committee of council of members. There is nothing in the legislation to indicate that they are to act in a capacity other than that of municipal councillors. In this regard, I must assume that the legislature was aware that in this capacity, the members of council will have fought an election in which the matter upon which they are called upon to decide may have been debated, and on which the would-be councillors may have taken a stand, some pro and some con. Indeed, the election of a particular councillor may have depended on the position taken. Furthermore, with respect to the enactment of zoning bylaws and amendments to zoning bylaws, it is well known that numerous committees are involved at which members of council are expected to vote before being called upon to hear representatives.
Mr. Mendes, I don't want to interrupt you because you're reading from the case, but we know those cases, and those cases in the category of policy decisions around planning, economic decisions, and so on, where what you're saying is before you have to make a decision, you would have a position, you would have a pre-decision. I'm in favor of building the road. That's what I campaigned on. Then the decision comes before me because I'm elected. That's not bias vitiated if I have an open mind. So the open mind, genuine decision-making cases fall in that bucket. I think that is so. I don't think you need to press that point. I think the point before us is that transferable where you have a rights-based challenge? That is what is before us, isn't it?
If I may just read this last part of it.
Sure.
In the course of this process, a councillor can and often does take a stand either for or against the development. This degree of prejudgment would run afoul of the ordinary rule which disqualifies a decision maker on the basis of a reasonable apprehension of bias. Accordingly, it could not have been intended by the legislature that this rule apply to members of council with the same force as in the case of other tribunals whose character and functions more closely resemble those of the court. And I will direct your attention as well, I'm not going to read it because of time, to Hot Holdings against Creasy, electronic page 1074, and the case of Minister of Immigration against GIA. This is at electronic page 1010. All of them make the point, and this is the important point, Your Honor, that in determining whether the extent to which the rule of bias applies, you have to take into account the fact that the legislature has vested powers in elected persons, ministers, elected persons, and I'm saying in this particular context, you have to take into account that the legislature is vested in a minister who will have political opponents and therefore who may be called upon to entertain requests for extradition in relation to political opponents. And therefore, in relation to those political opponents, you cannot say, well, you are infected by bias because you will benefit if this person is embarrassed by the fact that they have to face an extradition request, have to go through extradition proceedings, and possibly be subject to a committal by the magistrate and so on. I'm saying that in those, you have to take that into account, and it's very important in deciding the extent to which the rule of bias applies in this particular case. I don't know how much of the 15 minutes that I stole from the Honorable Attorney General I still have.
Six minutes.
Six, okay, that's great. So to answer your Honor, Justice Jamada, I'm saying that—
Mr. Mendes, 6 minutes is
Yes,
a
sir.
lot of time in certain circumstances, but not in others. One thing Justice Jamada was getting at, which I'm interested, yes, Justice Studley did recognize the political exception, and Sopica does as well. But do we see that there's a distinguishing element in circumstances where we are not talking about policy positions taken by governments or government ministers, but we are talking about ad hominem circumstances in which the allegation is that members of the government specifically said stuff about somebody. So it's a dominant situation rather than I campaigned on a platform or manifesto or doing X, and the decision I'm taking comes within that ballpark. We're dealing here with ad hominem situations of specific individuals, and they are saying they are targeted.
Well, Your Honor, this is not said about the minister. The minister has not said anything about the applicants. That is the first thing. What is being said is that the minister belongs to
in a sense. Yes.
Yeah, it belongs to a political coalition, and it is being said that at least the second applicant is a political opponent, not the first. The first is not a holder of any political office. Is her political opponent, and she will benefit from the issuance of the ATP. So I'm saying that we fall into the category of case that the legislature must have had in contemplation in deciding that it is the minister with the extradition functions who will exercise that power. And therefore, for the court to say, well, you cannot exercise the function because this is your political opponent, and therefore there's the well-informed and fair-minded observer would conclude that there's a real possibility that you would not exercise your functions fairly. That would be in effect to amend the legislation and to provide the category of persons that the minister cannot exercise extradition functions in relation to. And all of those authorities, including the decision of Justice Supingo, although it may have been dealing with councillors following government policy or taking positions that their party may have taken on issues and so on, the principle is the same. What is being said in those cases is that because you hold a position, because you have expressed a particular opinion and taken a position before, there's a reasonable apprehension of bias. They say it is in a different context in this case, but it's the same thing that is being said. You have an interest in the outcome of the issuance of the ATP, and therefore there is apparent bias on your part, which disqualifies you from making the decision. But the effect is the same if it is applied, and the effect is to undermine the legislative choice that is made to vest that power in the minister. And if I may make the last point, and that is, I rely on our submissions in relation to the automatic disqualification, and I just wanted to draw your attention. I was intending to draw your attention to a lot of the authorities, but we maintain that automatic disqualification does not apply for the reasons given, that it is the ex parte Pinochet case just simply does not apply. But importantly, in the decision of Bovis Homes Limited against New Forest District Council, relied upon by the applicants at electronic page 2508, the court says here, as I read the decision in Pinochet 2, automatic disqualification arising from a non-pecuniary interest is peculiar to those exercising judicial functions, which Councillor Drake was not. We rely on that to say that it could not apply in these circumstances either. And as far, again, if the test of bias, if the Mercer test applies as determined by this court, we respectfully submit that applying that test and taking into the account the fact that the informed and fair-minded observer must be taken to be aware of all of the facts. It means that the well-informed observer must be taken to be aware of the fact that it is not being said that that any of the prohibitions under the Extradition Act apply. In other words, it is not being said that the minister or that a different result was available to the minister. That is very important. That is why it's very important the questions that Your Honors were asking my learned friend before. Are you saying that a different result was possible? Are you saying that there was evidence that they are going to be persecuted because of their race? Are you saying that there was no third country arrangement or no specialty arrangement? Are you saying that it was not an extradition crime? The answer is that they have not been saying that. And it is therefore important to apply the test in those
in that context. Yes.
In that context. And
I think we have you perfectly well, Mr. Mendez. And I do believe you have exhausted the AG's generosity. So I think we will have to stop there.
Okay.
May I inquire, please, of my elders on the bench, Madam Justice Rajnath Lee and Justice Barrow, whether a break is indicated?
Let us slow down so that the Attorney General will not feel too.
I will come to him shortly.
Yes.
Not only your elders on the bench, I think it'd be a general question for everyone.
I'm sorry?
So it's not only your elders on the bench.
There are others as well.
I think it may be something to take
Do
a
I get
break.
the sense then that we should break for a few minutes?
I think you do, Mr. President.
Yes.
That's good.
Well, then if you do, you do.
Yes. So we return 12:45. Just a short health break. And we'll hear from you, Mr. Attorney General.
Thank you very much.
Thank you very much. Yes.
Aid Butterfly Black Seed, loaded with antioxidants and essential nutrients for your body's needs. Breathe better, feel better, live healthier. All the benefits of black seed oil without the taste. Aid Butterfly Black Seed Capsule. Study hard, work hard, play harder. Verb, nerve, and muscle power. Keep thinking and moving at any age. Verb, nerve, and muscle power.
By cartels and other criminals. The U.S. government makes it so that you can take 10,000 kilos of gold in Guyana, sit it in Miami, and not one person will touch it. It will be safe. And then you can then take it from there and to wherever you want in the world. And when you take it to that other place in the world, that other place, no one's going to touch it there either. Why? Because they know it's coming from the United States. Yeah. And so it means everything that Azzuddin Mohammed used Miami to send gold to Dubai. it means everything because he was using me, every taxpayer in America, every American citizen. He was using us to protect his gold that he was smuggling, not only when it was in Miami, but when it was in transit to Dubai and when it was in Dubai. Because here's what happens if some nation tries to go around stealing things from the United States. You can look at Iran and find out they get blown up. And so Azruddin Mohammed was using that protection to smuggle 10,000 kilos of gold out of Guyana, according to a criminal indictment given by a grand jury in the city of Miami in the Southern District of Florida federal court. So it was everything. And so now he has the indictment on him. Now he was already sanctioned, but now he's the opposition leader, and the opposition is being crushed and stifled and choked off domestically, and any international help they could get by getting a lobbyist, anything in the United States, anything to get some breathing room, they can't get because they're the leader who has to make the deal. He can't leave Guyana, and he can't communicate without everyone in the world knowing every word he's saying as long as he's in Guyana. He is becoming a dictatorship because of this situation. There's nothing anyone can do to stop it. Right? So with that said, I've been trying to help those who I can understand or position themselves for being able to, live in an oil-rich dictatorship.
Same here.
Good night, guys. A great night to all of those who tune into the realest thing in the world, coming to you from Guyana. Now, so much has been going on. So much I should be saying, so much as I should be doing. There's a lot going on. But there's a lot more going on there's a lot going on in my life also. So I'm working on that, working on issues. But work related, right? Could say, like I say, making money making, right? Thing doing. But these are issues that needs to be addressed. And sometimes I wonder, what's the cover up? What's the secrecy about? Huh? But then you watch at how concerning. I don't know if you guys know, if most Guyanese know, but most Caribbean countries, except for Guyana and Venezuela, Guyana and Trinidad, sorry, have difficulties going to the United States. Most Caribbean countries, people might not know that, but it is a matter of fact. So sometimes things come to my attention.
Big up to Cheryl, Bonita, Mia. Thanks for being a part of the live. Thanks for tuning in to Delta 9 Media. Big up to all the moderators right now in the chat. Big up to all the frequent travelers. Lyndon, what's going on? Thanks for being a part of this live presentation. Lyndon is saying this. The one of the Mohammeds attended this hearing. No, both of them. Both of them are in attendance. And as the screens shuffle, you would have gotten a chance to see that both of them were in attendance along with the legal teams. Big up yourself, Lyndon. Thanks for tuning in to the live. Lyndon is saying, why can't one of the Mohammeds attend this important hearing? Both of them are there. Both of them are being sanctioned, not just one person. There's now PTA meeting where the parents could attend in absence of you. You guys step forward and answer to the charges as well, because the charges are being placed on both of them, right? Big up to all the travelers right now that are in the chat. Mia saying waiting patiently in Miami for the Mohammeds. I tell you, hey, y'all in ordinary, you know, y'all serious in this chat. Big up to all the travelers nonetheless. Martha saying, I saw both of them. Yeah, both of them were there. Both of them were there. Indeed, both of them were there. You see the travelers, we paying attention, very observant. Plus, we are making sure we stay updated with all the relevant, important details with what's going on in the case. We want to be no sailors in what's going on. You know, we must be able to suss out exactly what the details are. So we're analyzing all aspects of what's being presented. Now, this is a conversation that was had a little while before this hearing would have started. Listen, you be the judge of what's being presented right here. Drop it into the comment section or call it in, because we're on break and we can take phone calls now. So we're going to highlight some of these far-reaching implications. Let's see it right now.
Attention. I know and see everything that's going on. I just ain't saying everything because times have changed as you get.
Being afforded the opportunity to bat so low down the order has given me a good vantage point, having listened to the erudite discourses that have transpired. And I think, Your Honors, with Your Honors' lead, a good point to begin is to remind Your Honors of what we know as trite and axiomatic principles in relation to extradition law. It is indeed widely classified and labeled as an area of law that is sui generis. It is of a special kind. The ordinary principles of law that applies to the ordinary functions of state, public organizations, public officials do not necessarily apply with the same rigidity, or some may not apply at all. And that is why when we deal with matters that are sui generis, sometimes we have to keep reminding ourselves, because some of the principles which apply are unique and can run counter to our basic understanding of what is fairness, what connotes propriety, etc. Extradition is one of them. It is based upon international law, and it has an unusual intermixture or admixture with domestic law. It involves treaty obligations. It involves comity and reciprocity. It begins with a process that commences by one executive to another, and it ends that way as well. In the interregnum, there is a judicial process, both enshrined in the treaty as well as in local legislation almost across the globe, that ensures safeguards and due process insofar as the law of extradition permits it. For example, the authorities are legion that at the committal hearing itself, fair trial principles are not engaged. For example, the right to a fair trial and to a fair hearing doesn't necessarily apply, as it appears in the Guyana Constitution, to a committal hearing. because the preambulatory language of that provision speaks to any person charged with a criminal offense is presumed to be innocent, etc., etc.
Now,
When you look,
Mr. Attorney, isn't that then a valid reason for the applicants to attack the ATP at the source? In other words, they know that the only way extradition process can begin is if ATP is issued. Without issuing an ATP, there will be no extradition process. So if you have an extradition process during which, or in the context of which, the fair trial, all those considerations we take for granted in criminal justice system will not apply, do the applicants then not have an interest in attacking what you call the door to make sure people don't get in to that process where these other rights do not apply? Is that an argument to validate their attack, which one might call a preemptive strike at this stage?
Mr. Nandalal, I don't want to be unfair. I don't know if you could take a note of that, but I really wanted to jump in before that because I'm not sure I heard you correctly. Are you saying that the Article 144 doesn't apply to committal proceedings? Because if so, that would be an extraordinary submission in my view. But I'd ask you for some authority for that.
Your Honors, if you look, Scantlebury, for example, dealt with it. Scantlebury from Barbados. It's not that it doesn't apply to committal proceedings. In an extradition hearing where there is no charge, because the provision says what it says.
There might be aspects of particular things where certain aspects of Article 144 mightn't apply, but you can't say as a general rule that due process rights, protection of the law rights don't start. Let me finish, please. Yes, don't start from the time of charging. I mean, you couldn't be making that submission, can you?
No, I'm not saying that, but I'm saying that the full impact of the article does not apply, and the authorities say so uniformly. And, Your Honors, I am not saying that the
Mr. Nandalal,
is not reviewable.
Mr. Nandalal, you say, Attorney General, you say something and then you say something else that has caused me pause. When you made that comment, I also made some notes to ask, but my brother has asked. So you say the Constitution is the supreme law, correct?
Of course.
The FOA is legislation in Guyana, correct?
Yes.
Is the legislation subject to the Constitution?
Certainly.
So constitutional principles govern subject to the legislation and the language. Won't you agree with that?
Yes, Your Honor.
So I'm very troubled when you say, maybe like my brother, I don't know, that, and I wrote it, right to a fair hearing does not apply, and I highlighted it and put it in bold, to an extradition hearing. Is that what you are suggesting?
No, not at all. Not at all.
No, okay.
Not at all. And the authorities...
Mr. Nandalal, if I'm not mistaken, but don't hold me to this, I think Scantlebury was disapproved by the Guyana Court of Appeal in the paper committals case. But don't hold me to that.
Thank you very much.
Sorry, not to pile on to the questions you have, Attorney General, but I wonder whether we have to cast our nets so widely. Do you think, because I know you have been generous with your time, and therefore you might want to shorten your run-up to the wicket.
Yes,
given where you're coming in the batting order, as you say.
Justice Usujui point, I am not at all saying that the ATP is not reviewable. In fact, we have conceded that. And where we part company is on what ground it is reviewable. So if I could get back to where I start, and Your Honor, I will abbreviate my run-up. The point is that when we review and examine the ATP function, we must take into account the context And that is why the authorities say uniformly that certain principles do not apply that would ordinarily apply to other public law functions. They do not apply to the ATP function. It is because of the peculiar nature of the ATP function itself. And that's the fundamental point I want to start with. And the other point I want to make quickly is that, that's the point I've begun by trying to make, is that as a country, Guyana has taken a position since independence in relation to treaty obligations, in relation to international law obligations, and that includes extradition matters. And as a matter of policy, once the statutory criteria has been satisfied, requests have been consistently granted. Of course, once the statutory criteria has been applied. And that is what has obtained here. And I want to move on now to deal with the ATP function.
Yeah, Mr. Nanu, Attorney General, as you move on to that, we had a lot of submissions. We heard a lot of submissions concerning 12.2, and I know you're going there. I wanted to ask you, as you address the court on that, could you let us know what is your role? What is the role of the Attorney General with respect to the exercise of the minister's power under 12.2?
Whereas the Attorney General under Article 112 of the Constitution is the legal advisor to the government of Guyana. And that will include advising the government and ministers and public officers on matters that may come before the Attorney General. In this particular case, two matters came. The Attorney General was engaged in two issues. And I believe Senior Counsel Douglas Mendez dealt with them. One was in relation to what is the position in relation to our treaty and its provisions regarding extradition to a third state. And that issue arose because there was a conflict between a full court decision in Dataram and the DPP and the King and the Director of Prisons. King being a higher court and King having settled the law, and cases subsequent to Dataram having approved King as the authority laying down the correct position. That was the advice that was offered. And in relation to the second issue, it simply had to do with whether the form was filled out properly. And all I advised the minister, there's a schedule and there are bundles of forms in the ministry itself, ensure that the precedents are observed. And
So
that's
if
the
I
extent
get you
in
right,
this
then yes, Honorable Attorney General, if I get you right, then you are not concerned to give the minister any advice on whether the order could not lawfully be made, or would not in fact be made in accordance with the act.
It's not that I'm not concerned to give that advice. Had that advice been requested, perhaps I would have. In this particular case, that was not requested of. Your Honor, it may be of some moment that in this particular case, the Honorable Minister of Home Affairs is a lawyer of nearly 3 decades standing and was a magistrate of Guyana for nearly 8 years. And I put that I believe in her affidavit, and that's the evidence before the court. Whatever moment is made of that is a matter for the court. But Your Honor, the ATP function has been examined by numerous authorities. It was examined by the Court of Appeal in Nogren. Home Secretary ex parte in Nogren. In that case, Your Honor, the Home Secretary was exercising similar powers that the minister in Guyana was exercising. And there was a request that came to the Home Secretary on a previous occasion. The Home Secretary engaged counsel for the subject, the fugitive offender, and the counsel was able to persuade the Home Secretary against granting the authority to proceed. The counsel wrote to the Home Secretary to say, if another authority comes, please hear us, inform us, and we'll make representation. A second authority to proceed, a second request came, and the Home Secretary issued the authority to proceed without resort to counsel. And the authority to proceed was challenged. It was challenged on the failure of the Home Secretary to grant them a hearing. Now, ordinarily, in ordinary law, I believe respectfully that the ordinary principles of natural justice and legitimate expectation would have been engaged, and ordinarily a hearing entitlement may have arisen. The Court of Appeal rejected that argument and said that the ATP is a gateway function, it is a special function, it is administrative, and it doesn't lend itself to the principles of natural justice.
We follow you there, Mr. Attorney General, very clearly. I would like to go back to the question asked by my sister and your response. You suggested that your advice was sought on the two matters, and you rendered that advice. But, you know, the elephant in the room is that the applicants, stroke appellants, are alleging that the Attorney General made several statements in public which indicated a certain mindset as regards the treatment of any request for the extradition of the appellants. And further, that the Minister of Home Affairs was present at certain events where those statements were made. And I assume the implication is that whether advice was granted formally is of no moment, because the Attorney General had made clear what the position was of his office. How do you respond to that, sir?
Let me add to that, Mr. Attorney, because the President's question is very hugely important. I'm interested in it, and I want to add this to it so you can hopefully address both. In specific terms, the complaint, from what I read, is that the Attorney General cast criminal aspersions against certainly the second applicant. And the Attorney General had a running commentary, an ongoing proceeding, the extradition proceeding, and that the Attorney General basically cast some innuendo on the magistrate hearing the proceedings. Can you please take those into account and advise us of the propriety and fairness of that? I know the Attorney General may be a politician, is a politician, but the AG is a lawyer first.
Thank you very much. Your Honor, it boils down to whether the principles of bias attend to the ATP in this particular context. The case of the applicant is that the bias arises from political rivalry. And we say respectfully that political rivalry and bias in this sense does not apply to the functions of the ATP. Warner, the Privy Council essentially ruled that, again, natural justice doesn't apply, while they were focusing in that case on the right to hearing. When one examines the Court of Appeal decision and the Privy Council decision, they use the term natural justice and a right to be heard interchangeably. And that is why, Your Honor, we have relied on a number of cases where political dispositions and policy positions were accepted by the court as appropriate factors to influence a decision in a particular way. And
Mr.
we say
Nandala,
that those
if I may,
principles
sorry to interrupt
apply.
you. Mr. Nandala, sorry to interrupt you. I'm not sure that you're getting at the question, though, that was asked of you, because you seem to be reducing it to political rivalry. But I think the president's question was directed specifically to statements made by you that actually concerned the extradition specifically, and making statements about what the extradition was, what the outcome should be. And then, as my brother added, statements in relation to how the magistrate was treating the case. So it's not just about political rivalry in the air or generally, but concerning specifically the subject of this case.
Your Honor, I can't recall ever projecting the outcome. What I have said, I've spoken about the extradition proceedings, and I've expressed concerns about the time that it was taking in the magistrate's court. Matters of that nature, matters that are in the public domain that Guyanese generally were speaking about. I don't think that I went anywhere close to expressing a view about a particular outcome. And in relation to the other cases, the other matters, when you examine even the affidavits of the applicants, I was referring to matters, and not by myself alone, during the political campaign, which preceded the request. The request was not received as yet. But you had in the public domain the fact that the applicants were the subject of OFAC sanctions. You had the fact that there was a writer's special report published on the 14th of July 2023, long before their entry into politics, that identified them, and these writers, this is worldwide, identifying the applicants as being investigated by the DEA, the FBI, the Department of Homeland Security, and other U.S. agencies on suspicion of smuggling Colombian cocaine and illegally mined Venezuelan gold to United States, Europe, and the Middle East. The report further states that the applicants were also suspected of laundering money for drug traffickers and criminals, including sanctioned Russian nationals operating in the region. So, the court have to take into account respectfully that there is a political campaign going to, politicians are speaking, they're competing for office. Justice Barrow spoke about the applicants himself admitting him being a fierce critic of the government. You have a politician here who is opposing, and this is his rap sheet. This is what we have to speak about. He was criticizing.
I don't think anybody disputes the fact.
So I just say that, Your Honor, so that we understand the context.
Honorable Attorney General, if I may, I do not believe anybody disputes the fact that there are indications in the public domain, allegations against the appellant. There's no difficulty, or the appellants. There's no difficulty there at all. I think what we're trying to tease out is whether, given the very high office that you hold, and given your functions that you perform in relation to this matter, you're the chief legal advisor to the government, whether on reflection you think that, I've forgotten the word used by my brother Ibo Osuji, this was a proper or the best way, I should say, to express the government's position. I mean, there is a difference between, I imagine, other ministers, other members of the government making statements, and the Honorable Attorney General, who is the chief legal advisor to the government making statements. And I think we are not, drawing any conclusion or making any findings, but we are just wondering whether the Attorney General making those kinds of statements to which the appellants refer is the best practice for the kind of society and democracy that we seek to encourage in Guyana.
The Attorney General did not make any decision here. The minister made the decision, and the Attorney General advice was limited in its compass, as is the evidence before it. The ministers, and then I wish to dwell a little on the role of the minister.
Yes.
So, Your Honors, first of all, there is some contention that the minister is not named in the legislation, and there is some argument because of that it can be delegated to any minister. Your Honor, that issue was addressed by our courts in Sobers a very long time ago and settled that the Minister of Home Affairs performs that function, performed it then, performed it since independence, and has been performing that function since.
Mr. Sorry, sir. Sorry, I need to return to this. The question is not whether the Attorney General made any decision. The question is the position of the AG in government and in the context of this case. You started your submission by saying the Attorney General is the legal advisor to the government. And in that capacity, the AG advises the government and ministers. And here we are talking about the complaint of the applicants that the AG was making certain comments on the basis of which they are now claiming that the whole process is tainted by bias. And the concern is whether the Attorney General of the country should be making those comments that have been alleged against him in the context of this case, casting aspersions, running a running commentary on an ongoing judicial process, the extradition process, suggesting that by innuendo about the failings or not of the magistrate handling the case. Yes, you say that these are comments in the public domain. Is there something to be said that it is part of the job of the AG to bring the population back to saying, look, respect the process, let the process take its course, rather than making comments that might add to that negative public view on the matter? That's what I'm interested in. I believe, I don't know whether the president goes as far as that, but that's
let me assure you that the Attorney General did not make any improper comments. The comments that were made were in their proper context. They may have been misquoted and used for political purposes, but they were not improper statements.
Okay.
And they were made in due regard to the administration of justice and the right to form and express opinion.
We hear you, Attorney General. I think we can move on from that point.
Thank you very much, Your Honor. So Your Honors, again, I come back to Warner. In Warner, Warner followed Noblin in holding that the ATP function was special. it was a gateway function, is purely administrative. And there's a whole body of administrative functions that do not attract the full rigor of natural justice and all the other principles. Not that an administrator performing an administrative function is not required to act fairly. There is always a requirement to act fairly. But there can be situations, and there have been situations, where an administrator can act fairly, but natural justice is not required or employed in the performance of that particular function.
Honorable Attorney General, I think just to nuance what you're saying, I don't know that the natural justice point as a right to be heard is what is being advocated with rigor here. What I think is being argued with greater rigor is the tainting of the process by alleged bias and a debate on which is the relevant test. I thought where you may be going on this is to say that the general Porter and McGill test is not apt, as Mr. Mendez has suggested. It's a different test. But I noticed that you say that the Warner case held that the ATP is purely administrative, but I don't think are you suggesting that administrative actions do not attract the supervisory jurisdiction of the court?
No, not at all, Your Honor. In fact, in our written submissions, in the reply, the applicants seem to think that we have said so. We are not saying so.
So if we agree, right? So if we agree that the decision on the ATP attracts the supervisory jurisdiction of the court, I think we know it's clear that you agree to that. Yes. The question, yes, do we agree to that?
Yes, Your Honor.
Good. So the question becomes, in this case, whether or not a challenge on bias is available. First, conceptually, is a challenge on bias available to the applicants at this stage of an ATP? I raise that because there is a way of reading the Court of Appeal that suggests this may not. So I just want to be clear to understand what is your position. Is it that in your position, in your perspective, a JR challenge on the basis of bias is available at this stage to challenge an ATP?
Generally speaking, yes. If there is any relationship of a pecuniary nature, etc., the ordinary principle, yes.
Okay. What would you say is that test? How do you frame that test? What should be the test? Because I accept the principle way back, the principle of fairness is not one fixed form of fairness, it is contextual. In public law, we understand that. So how would you frame that test?
I respectfully say, Your Honor, that the test must be absent those disqualifying factors. Those disqualifying factors must be absent. And this is a political act, it's an executive act. The authorities have even described it as a diplomatic act. This particular act, once those disqualifying factors are not present, and also one has to look at the policy nature of the decision.
So are those disqualifying acts for you?
It is not reviewable on that ground.
So for you, are the disqualifying acts limited to personal and or proprietary interest? Is that what you are saying? When you see, you use that expression a few times as absent the disqualifying acts. What do you mean specifically by that? Are you limiting that only to some sort of proprietary or personal interest?
Personal, financial, etc.
Limited to that?
Yes, Your Honor.
All right.
And Your Honor, if I may go to...
Oh, sorry. Attorney General,
with-
1 second.
Yes.
1 second, please. I'm interested in an exchange you've had with my learned brother, Mr. Justice Jamata, when you say Potter and Maygill is not apt. I'm not sure I see why not. I'm not saying I have a view on it, but I'd like to know why Potter and Maygill test will not apply from at least an adapted version of it, to the extent that we are saying, well, the test for bias has to be seen from the eyes of a reasonable, well-informed person acting in good faith. I'm adding that. In other words, they need to know the circumstances and then ask themselves that in all these circumstances, do we see bias? Isn't there an adaptation of that in this discussion?
I'm not saying that Porter and McGill doesn't apply. I'm saying that Porter and McGill speaks on informed, sensible, prudent bystander who would take into account the particular factual context here. You see, Your Honor's Parliament
so the point being, your
vested
point
this
being,
power.
is your point then being that it does apply to Potter and McGill?
Yes, and we have said so in our submission.
Okay,
We have
sorry,
said
I
so.
just wanted to be sure.
And
I
we have
thought I heard you say
detailed,
that.
yes, and we have detailed
Attorney
once
General,
applied.
I don't want to press the point, but my note is the Attorney General's position is that the test in Porter and McGill applies, and you've said so in your written submissions. I may be wrong, but I think that is at odds with what Mr. Mendez has put forward for the first respondent. I think Mr. Mendez has said, and if I'm wrong, Mr. Mendez, please correct me. I think he has said that in this case, the Porter and McGill test is inapt, and in fact, the appropriate test is a different standard test, which is, I'm calling it a public policy test, but it is the test that suggests that all that is required is that the decision maker have an open mind and make a genuine decision. Now, it may sound kind of the same, but there is a significant difference in public law between those two tests. So why am I saying this? Because I want to be very clear on the record that you are of the view that the Porter and McGill test does apply, but when we apply it in this case, there will be no outcome of bias. I just want to be very fair to you about that. That's why I have said what I have said. Is that your position as the Attorney General?
No. If the test applies, bias is not a factor. When one examines all the relevant considerations, a politician can be biased and still act fairly. The test is, did the minister act fairly? Did she follow the statutory conditionalities? Was she influenced by something irrelevant? Was she the authorized person to perform
No,
the function?
you see, Mr. Honorable Attorney General, we have to write a judgment, I assume, at some point in time, and we have to try and understand what the law is before we apply it. So therefore, just to be very clear, you are agreeing, therefore, that from your point of view, the Porter and McGill test does apply, which is the note I made earlier. I just want to be sure, yes?
It does apply, but once it is applied, then all the factors will be taken into account, and it would conclude with the contention or a possibility of a contention that if a person exercising that power is politically influenced, then that doesn't affect the fairness, the legality of the decision.
The Court of Appeal staged it differently. I think the Court of Appeal came into Porter and McGill as a backup reasoning. Court of Appeal said, to begin with, the test for fairness or bias is not engaged because it is a ministerial function, not judicial. And then say, but in any event,
and that's exactly
even if that argument fails, then Porter and McGill doesn't give you a finding of bias. Is that my understanding of what the Court of Appeal said?
Yes, and we have adopted that position.
All right.
As the very position. So, Your Honor, if it is unclear where we stand, we say that Pinochet disqualification doesn't apply, and even if, and that's the exact manner in which we have expressed it. Your Honor, there's a passage dealing with automatic bias. There's a passage that I want to share with Your Honors. And it's taken from Administrative Law by Sir William Wade, the 10th edition, the 11th edition actually. And they're quoting from Lockerbie, but they have expressed it in a manner that I find very, very interesting, and I would like to share it with the court. And Lockerbie, as the court would know, was decided 1 year after Pinochet. And this is the caption that I want to leave with the court. I sent it along with the authorities. In a leading case, the Court of Appeal, speaking with the special authority, this is the Court of Appeal of England, speaking with the special authority of the Lord Chief Justice, the Master of Rolls, and the Vice Chancellor, be very important and powerful functionaries. Together laid down that while everything will depend upon the facts and nature of the issue to be decided, objections could not be based on religion, ethnic or national origin, gender, age, class, means, or sexual orientation of the judge, nor ordinarily with the judge's educational, social, employment, or service background, nor his political associations, professional associations, example, membership to the inner court, membership of social, sporting, or charitable bodies, or private decisions, etc. None of these grounds, they are saying, cannot be a basis of objection against a judge. Now, in the judiciary, in the realm of state authorities and powers, the law exacts from the judiciary the highest form of impartiality when performing judicial functions. And they're saying here that the judges' political associations, etc., are to be discounted and not to be taken into account, or cannot be the basis of challenge. That principle, I dare say, with respect, must apply a fortiori to a politician, a minister, exercising an executive function in a political environment. And that is why we say respectfully, Your Honor, that the ATP doesn't attract the rigor of the bias doctrine as it would ordinarily apply even in administrative tribunals. That is why the legislature vested that power in a minister, and it appears on its face that it is non-delegable. And I advance that proposition as part of my general submissions moving on to a different issue. And I am happy that the court identifies the difference in the language of the draftsman in section 12, where the legislation devolves a responsibility on the Foreign Affairs Minister, but permits right there upon that devolution, permits a delegation.
Yes, Mr. Attorney General, thank you very much. I know you're going to go on a little bit further on the delegation issue, but just to draw a line under the question of the test and whether bias is relevant, I do think that the Court of Appeal did make reference to the fact that bias is applicable regardless as to whether the act is described as judicial, quasi-judicial, or administrative. That was clearly said, but of course the factual context.
That's
factual
correct. That's our
context has to
position,
be
Your Honor,
considered.
respectfully.
Absolutely, and she went on to say, this is the author of the judgment, quoting from Ramdas, that procedural justice, obviously, applies. And I believe that was also the view of the Privy Council in the Warner case 2022. So that the point is that procedural justice obviously must dictate the conduct of the minister in deciding whether to grant the ATP. I thought I would just say that because we may not have been quoting exactly verbatim from the Court of Appeal, but the Court of Appeal did in fact suggest that procedural fairness applies in relation to decisions relating to the ATP.
And Your Honor, I have said so. That is why I am saying there is always a duty to act fairly. Yes. But that doesn't necessarily mean one must engage natural justice to act fairly. In fact, when one reads back CCSU, when Lord Diplock formulated those three heads, irrationality, procedural impropriety, and I believe was illegality. In dealing with procedural impropriety, in explaining why he did not use the term natural justice, is because he conceived of situations where procedural impropriety can be achieved, but the context may not permit the application or doesn't warrant the application of natural justice principles. Lord Ruskin in that very case also said that it's better to let us put the term natural justice to rest and use the term to act fairly instead. And those are the principles, Your Honor, I respectfully ask that we engaged in considering. I'm not at all saying, and the contention, as I understand it, of the applicants is not that they are making an allegation that the minister acted unfairly. They are saying that the minister is infected with the bacteria of bias. In fact, the entire government is infected with that bacteria. And that ipso facto and without more is the germ that is enough to invalidate the decision. And we say respectfully, that is not the law that ought to apply to the ATP function. And that is why I share that passage from Wade, where Wade is saying that even the judges' political association, if they have, ought not to be taken into account. In other words, the Pinochet case has been narrowed significantly in its application. And we have quoted authorities that have narrowed it down too.
I did not mean to provoke you into another flight into this area, Honorable Attorney General. You're going on, I think, to the non-delegable nature of the functions.
Yes, please, if I may resume there with your kind permission.
Yes.
So Your Honor, where the draftsman wanted the delegation to take place, the draftsman authorized the delegation. Where the draftsman wanted the minister to perform, the power was vested with the minister. And there is a reason. That's why I began the way that I began, by adverting to the nature, the political and international nature of the obligation in relation to extradition. And if I may go quickly to Prune, as reference was made to it repeatedly. Prune says this, speaking about the desirability and the necessity of the minister performing the function. Prune at paragraph 76 says the expertise of the decision maker is the most important factor. They were speaking about the ATP. The expertise of the decision maker is the most important factor. The minister has the expertise in political matters, international relations, and the ramifications of the law of extradition. It is the minister who must consider good faith and honor of this country in its relations with other states. This necessitates a high level of deference. So, Your Honor, when Parliament in its wisdom and for great reason, as is exposed here, repose that power in a minister. I say respectfully that we should really be careful and approach it with great circumspection when considering authorizing a delegation. Justice Volcan had asked a question. Oh, sorry.
Mr. Tony, I do not know whether anything writes on this, but let me ask it anyway. The Interpretation and General Clauses Act is Cap 2. The Fugitive Offenders Act is Cap 10. Now, whether or not there's any reasonable rhyme to the enumeration in that way, it's neither here nor there, or maybe it helps. But in drafting Section 12 of the Fugitive Offenders Act, could the Parliament not be presumed to know that the law elsewhere would allow or did provide for Minister of Public functionaries to delegate their functions, and therefore would that not require for Parliament to have a more explicit in Section 12 in saying only the minister can do this? If I was to, well, without prejudice to any other, law in the country and all that stuff, is that too much to expect of Parliament to know that they would know that the Interpretation Act might have thrown something of a curveball in how we read Section 12?
Your Honor, I'm happy that you have situated the acts in a chronological type of order, because the General Clauses and Interpretation Act predates the Extradition Act by many years.
Yes, okay.
By many years. Therefore, the draftsman, when he drafted the Extradition Act, and he wanted it to be delegated, he delegated it. He knew the provisions of that act, but he still delegated it when he wanted it to be delegated in Section 12. When he wanted to be kept,
yes,
he kept it.
Shouldn't that sequence of that chronology have influenced or informed the draft person to be clearer in Section 12 in saying minister without prejudice to any other law, minister?
I say, Your Honor, I come back again to the peculiar and sui generis nature of extradition. The extradition, the Fugitive Offenders Act, is a sui generis legislation. It's considered to be a self-contained code. It has its own appellate process and appellate challenges, etc., at the judicial level. And I ask that it be generally construed that way. And as a self-contained code, the draftsman delegated powers when he wanted to delegate powers, and he did not do so when he did not want to do so. And I want quickly to go to Vroom, and perhaps it will bring greater clarity, because Justice Volcan had asked the question of Mr. Mendez. Vroom, the statutory formulation is different. In Vroom, the judge, when examining the statutory landscape, described the ministerial functions at two stages: ante the judicial process and ex post facto the judicial process. Ex post facto the judicial process, that is the surrendering stage. The legislation in Canada used the term personally. The minister shall personally. And because the term personally was used, the court interpreted the ante-judicial stage, that is the ATP stage. It speaks to the minister, but they said because the draftsman used personally at the end, then if it says only minister, the implication is that the minister can delegate. They construed it in a self-contained manner. And I'm inviting this honorable court to apply the same canon of construction, because you have section 6, where there's a delegation, and you have section 12, and there is no delegation. There's another reason, Your Honor, why Parliament wants the minister to perform this function and has made it inalienable. One, it's an executive function. Two, there is an institutional framework that attend the functional obligations of the minister in international law and treaty obligations. There's a repository there of institutional resources available to the minister. And that's why it is the Minister of Home Affairs who has been exercising those and related functions. There's a criminal assistance and mutual assistance platform, international platform, that is located within that ministry. And it is for that reason that Froome says that the expertise of the decision maker is the most important factor. The minister has the expertise in the political matters, in international relations, etc. That is the ministry
Attorney General,
that deals with those functions.
I mean, I want to ask something slightly different, but I take your point about the executive function. But in terms of the repository being in the ministry, ministers come and go. And if the repository is in the ministry, a PS, I'm sure, who is more permanent and usually there for several regimes, would have access to the repository. But be that as it may, let's go along with the idea that the minister must make the decision. Are you in alignment with what Mr. Mendes suggested was a proper response to propriety in the system, that if for some reason the extant minister or the involvement of the minister in the process would have contaminated the process, that a proper response under the rule of law would be to take that extradition portfolio and place it in another person. In other words, the recognition that personal bias could contaminate a decision, and the remedy that you remove the person who is implicated and substitute another person. And so that the idea of delegation, in a sense, has been to another. A part of it has been to maybe a non-minister person. But is there a sense in which you can not delegate because you are created either an acting appointment or a temporary appointment, I don't know, but you remove this person who is contaminated out of it while preserving the ministerial function? That's what I understood Mr. Mendes to be suggesting. Do you agree that as a question of law and principle, that is an available and appropriate response?
To whom the contention of the applicants is that the entire executive
No,
power
I'm not, Mr. Attorney General, I'm not on the facts as yet. I'm on the concept. I'm on the principle. I'm trying to work out for now what would be a theoretical model. It may be on the facts, as you are going to say, no doubt, that this doesn't arise, but I'm just trying to understand what is a theoretical model. Be on delegation. So delegation, as I understand you, it cannot be delegated from ministry. That's what I understand you be saying. So I'm trying to draw a distinction between ministry as repository and a person who happens by the coincidence of presidential appointment to be minister. What is more important, the minister or the person who holds the portfolio, or a person who holds the portfolio and has access to the ministry's, as you put it, repository of experience?
Can you answer in a short shrift, because we have to move on?
If the person is disqualified by law, then another person can be substituted. Once they remain in the, because that will not be a delegation. That will be a substitution.
Okay.
Very well. Thank you. Mr. Attorney General, you have clawed back all the time that you gave to Mr. Mendez.
So can I borrow 10 minutes from Arun Dasai? I don't believe that he will be speaking.
There was no time assigned to Mr. Gusai.
Very well.
So can you wrap up in 5 minutes,
I
please,
just
sir?
wanted to leave with the court one last argument, and it is the policy argument, which I'm sure that your honors would have read. It's all in my submissions. That while there is a policy position, the decision maker is entitled to take a position that may be biased towards that policy. And I have articulated and respectfully submitted in my written submissions that there is a policy imperative that is at work here concerning extradition. While there's no duty to extradite, and that it's not mandatory to extradite, once the criteria have been met, then one would expect that the policy would be followed. And that policy was followed in this case. And all the safeguards, all the challenges that the applicants wish to make, they are free to make at the judicial process that will ensue. And there's a whole line of authorities that speak to that. I have here folks on admin law, and if I may respectfully direct your honor's attention to the relevant pages, it has to do with where the type of cases, like for example, the policeman who's about to charge. I think Mr. Mendez spoke about that in his written submission. That was one of the analyses given by Gregory Smith, Justice of Appeal in Warner. And there's another one in Wiseman and Borman by Lord Reed, where Lord Reed said that it cannot be that every time a public officer is going to institute charges, that it must offer an accused person a hearing. In Warner case, I believe
Mr. Nanalal, I think I could certainly agree with you with those propositions. But certainly, can we equate a police officer charging with the this procedure under the Fugitive Offenders Act, especially in the context of a section like Section 12? In other words, is there an equivalent obligation on anyone that mirrors Section 12 when you come to charge in the normal criminal sphere?
Your Honor, if I may be briefly with Section 12. And I will end after that. Your Honors, we have to be, but I can't tell the court to be careful, obviously the court is careful. Section 12 has to be interpreted with some degree of realism. Now, Section 12 is nothing new to Guyana. Section 12 is not an exceptional provision in Guyana law. In Nogrin, the Home Secretary made an error in interpreting the law when he prepared the ATP. And the court said that nothing is wrong with that. That doesn't invalidate the process. It doesn't render the procedure unfair, because there is a judicial process that will deal with the law. Your Honor, if a minister is to perform the function with the complexity and the onerousness that is being urged by the applicants, I dare say, first of all, that minister must be a lawyer. That minister must be a lawyer. And I even went, that minister has to perform a tremendously onerous task. And that is why I have a case here from Trinidad.
My Honorable Attorney General, you have to wrap up. 2 minutes. I'm sorry, time has gone.
So Your Honor, that is why they use in the language of the legislation, they say that if the minister is very subjective, and I quoted a case, Your Honor, ex parte Hill, where the language was similar, ex parte Hill. And the minister in that legislation, has many legislation too, They require the equivalent of the local offenses to be stipulated. And the minister got it wrong. As the minister got it wrong in Stokes and Bisham Barrage in Trinidad.
And the court is there to correct the minister if the minister gets it wrong.
Precisely. The court said that we will review that.
Yes.
So the point I am making is that the minister's function doesn't have to be as pure as Caesar's wife. The minister has to perform a function, but that function is not conclusive of the matters. The matters are going to be reviewed at several tiers and stages after by the proper tribunal that shall solely and exclusively and conclusively determine the matters of law.
Thank you.
Thank you very much.
Thank you very much, Attorney General. Sorry for impeding you in mid-flight there, but the time has really gone, and we understand your submissions, and we have your written arguments as well. Mr. Gozai, you're not going to prove me wrong, are you? Do you wish to take the floor?
No, please, Your Honor.
Prove me right. Excellent.
Your Honor, could you indulge me for 10 seconds?
Okay, 10 seconds.
Just simply to say that the references made to what the Honorable Attorney General may or may not have said in relation to the magistrate and the conduct of the extradition proceedings would be irrelevant to any challenge to the ATP, because those statements, whatever they were, would have taken place after the ATP had already been delivered. That's the only point I wish to make.
Thank you. Applicants, appellants, do you have a response to?
Yes, very short. It shall be as short as possible. I'll address the little friend's comments first. The court is entitled to take into consideration all the matters that occurred before the ATP and the matters that occurred afterwards. And the case on that is Contran, which is in the list of cases which is contained in the supplemental bundle to the reply. That's point number one. So that is incorrect. The second point is that the attorneys representing the appellants, the applicants, raise the issue of the time for 4 hours, which is an important issue in respect of bias. In the reply submissions, reply affidavit filed before the Chief Justice at paragraph 20, and they also raised it in the CCJ application at affidavit at pages 81 and 80. Paragraph 81 and 80. And that's the affidavit that you have before you. So that matter was specifically pleaded. The third point is the Attorney General not only made statements about extradition before the actual ATP was issued, but he continued to make statements after the ATP was issued, and he continued to make statements while the preliminary inquiry was going on. The third issue, he advised the Attorney General more extensively than is said to the court today, and that, the Minister, more than was said to the court today, and that is found, first of all, at paragraph 39 of the AG submissions at first instance, 39 and 40. And it says as follows. Shall I read it for you, Alan? His role was limited to responding to inquiries made by the minister in the course of a statutory function. These inquiries were directed to pure questions of law, including the application of the decisions in King and in Datiram, particularly related to the conflict with the two authorities. The advice proffered, paragraph 40, the advice proffered was that the full court in Datiram was bound by the Court of Appeal decision King, and under the doctrine of stare decisis, had no jurisdictional freedom to depart from it. And the King represents the current law in Guyana. And Article 7 of the treaty embodies the specialty rule. The Attorney General provided his advice in furtherance of his constitutional rule under Section 112 of the Constitution. I make 2 comments to that. Sections 39 and 40 of the um, of the affidavit. I make two comments on that. The first comment is that Section 7 of the treaty prohibits an ATP from being issued.
Article 4 of the treaty.
Article 4 of the treaty, sorry, prevents ATP from being issued when there are pending charges. Article 4 of the treaty prevents so that advice was wrong, respectfully. So
prejudice could have arisen in any
prejudice could have arisen in any event. And the second point in respect of that is that an Attorney General who made comments about extradition before the matter began, it was issued, made comments during the course of the preliminary inquiry, gave advice to the magistrate in respect of the ATP, is, in my respectful submission, given advice in respect of the decision. It is law that the materiality of the advice is not important, nor is the fact that the participation is enough. So materiality is not important and participation is enough. And
Counsel, sorry. Let me make sure that I understand you. Are you going as too far as to say this on that point, that you have no problem with the substance of the ATP? If the DPP, as you suggest, or any other functionary who is not a minister, had issued the same ATP, you would have no problem. But the problem is that there's
no non-biased person, Millard.
But I mean, you mentioned the DPP. You mentioned the DPP. You recommended the DPP as a possibility.
Or a permanent secretary or some.
Oh, a permanent secretary, fair enough. Yeah. So if any of those are issued the same ATP, you would have no difficulty.
But we mean
if there's no bias, and if all the rules are followed and if the law is complied with, we have no problems with that.
Okay.
But it is for the state to do that. So therefore, getting back to this point now, the level of participation is not important. What is important is the participation. And the second thing is the materiality of the participation is not important. Participation is enough. And that can be found in three cases: Delagio, Porter and McGill, and Paris. Right? If I may read this extract from the case.
No, please, if you just gave us the reference, we will read it.
The reference.
The guillotine comes down in 4 minutes at 2 o'clock. Please.
Yeah, the reference is the case of Delagio at page 153, subparagraph 9.
Right.
Subparagraph 9.
What's the test?
No. The other point I wish to make is that the quality of the decision made by the Attorney General is not important. What is important is the qualification. So therefore, all the other matters are of no interest to us at all. Whether she followed or did not follow the advice of the AG, whether she took a decision was rational or proportionate as the case may be. The question is she was not qualified to make that decision because of the fact that the case of Bube says appearances are what matters, because bias is often insidious. Bias is often insidious. Sometimes.
With respect, counsel, I think we have heard that point before. Is there any further point in reply you wish to make, arising out of what was said by the other side?
Pre-existing charges.
The final point is that we have made it. We have made a point already. Pre-existing charges. The test now is a unitary test, and in respect of.
I am not sure I heard anything about pre-existing charges from the other side.
Well, that's mentioned in the affidavit of a little friend.
Yeah, but you're replying to what they have submitted. I don't recall that being said.
All right, okay, very well, Millard.
That we couldn't point to anything reckless or do anything wrong. He said we couldn't point to minister doing anything wrong.
Yes, the question of pointing to the minister doing anything wrong is not, we have not reached there. We are at a pre-minister doing something wrong stage, if I may say so, not doing something wrong stage. We are at the anterior stage, and the anterior stage is the qualification to make the decision because of the location of the minister and the appearance. The potter and guilt test is about appearances. It's not about what in fact was done. And it's whether a fair and informed observer, lay observers, Justice Balkan said in his recent judgment, a fair man and informed observer, having known the facts and the appearances are what count.
Very well. I think we have that point very clearly. Thank you very much, Counsel.
There's one point that Mr. Ford wants to make, and says he'd be no more than 2 minutes in respect of it. Go ahead.
Well, I think the court will decide whether he goes ahead or not. And right now we have 1 minute. If you want to make a point in 1 minute, Mr. Ford, was that what it was? Yeah.
Thank you, Honors. I will make the point in 1 minute, Your Honor, and I'll divide it accordingly. Your Honor, I just wish to come back to the question in relation to delegation and to make the point that the Interpretation of General Clauses Act applies by the provisions of the very Act unless they are specifically excluded. Okay. The other point I want to make, Your Honor, deals with the case of Imperial oil, which has been cited by Mr. Mendez. The respondent's case in relation to Imperial oil and the entire tests which they have been built upon are cases predicated on the existence of a policy. There's a reference in the Smith Judicial Review of Administrative Action at third edition, pages 222 to 223, in which the court says that the normal standards of adjudication cannot meaningfully be applied to a body entitled to initiate a proposal and then to decide to proceed with it in the face of objections. All the cases cited by the respondents, Your Honors, on this issue deal with situations where the respondents, the minister, the statutory official, is entitled to initiate a proposal. And they are elected on that basis, and then they go into government and they implement policies based on their situation, their peculiar situation. This is a radically different situation from what we have before.
Yes, Mr. Ford, I take the point. In fact, it may not have been you who said it, but it was certainly made earlier. I think we follow that very, very clearly. There's a distinction there. Thank you. I'm going to thank you very much for your submissions, Counsel, and also Counsel on the other side as well. May I ask you, and I'm trespassing a lot on your good nature, but could I ask you to just stay in place for about 5 to 10 minutes at the most? We're going to confer and come back to you in about 10 minutes or so. Please stay in place. Thank you very much.
They still call me, I still help a lot of people call me on a daily basis to address issues and raise concerns with me, for me to highlight their issues. This is one of those instances that I gotta come out now and address things that, you know, it seems that most of the politicians have been bought out. Now, my concern is things that would happen that would affect Guyana as a whole, most Guyanese. And I'm going to be quick about it. I don't want to spend more than 50 minutes on this. Azzedine Mohamed, the now opposition leader, who's fighting extradition, recently had his lawyer send a letter to the US ambassador for her to not get involved or say anything about a pending matter of this magnitude. Because the Mohammed's them liars saying everything they want to say, but nobody else mustn't answer. The Mohammeds could say anything they want to say, but nobody else mustn't answer. So when I get this wire and receive the receipts of said situation that I'm going to talk about now, I was like, didn't the lawyer tell the Mohammeds?
Eat butterfly, sea moss powder. Take your daily routine to the next level. Natural vegan superfood powder, essential multivitamin powder made just for you.
There's a time where as you look at American calculate, there's so much diplomacy that has to be used before people are affected. Not with Trump. Not with Trump. Trump does. Say, look, a bombing boats. Dead sense not even pick you up. We don't want to be seen, Guyanese don't want to be seen cooperating with enemies of the United States. We want part and parcel of her.
If you could hear me, right? What y'all think about who we was listening to right there? From when I was watching and paying careful attention, it seems as if, just my perspective, but when the Attorney General came on and he started to speak, to a point you even hear one of the judges refer to the way that he's addressing the court as frantic outbursts. I mean, I could stand corrected, but I'm trying to paraphrase as to what I was hearing, right? Y'all didn't realize that from the way that the case was brought over from the Attorney General's side, it's kind of like if they help to prove the presentations of Ford on the other side of the court. That's why I'm picking up so far, but I mean, I could be completely wrong. They're deliberating right now. We got a number of persons in the chat. Shout out to Garden. Thanks for being a part. The live Garden is saying the AG slipping all over with his big words, right? It's crazy how the other judges are not trying to articulate in ways that are so elevated that they lose the audience, knowing that persons are going to be covering and paying attention all over the globe to what's going on with this, right? Big up to Janet. Thanks for being a part of the live as well. Janet is saying your observations are on point, Delta. Big up yourself. We got so many people in the live. Big up to Cypher. Cypher dropping the nines. We coming through clearly. I see Dan. What's going on? I see Dan is saying Rosedale Ford is a much more qualified lawyer than Anil. And we could see Anil is all bluff. with no substance. I tell you. Pick up yourself, I see that. Thanks for dropping insightful commentary in the comment section. Black man saying this. They need to see the real criminals. I'm telling you. They're just saying the defense need to sit down before they make matters worse. Yeah, because they were going off so much to a point where one of the judges had to ask them, hey, but how you disagree with him? I will come on you side before you. You're agreeing with what he said. You're agreeing with such and such. Because he said da 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 da, but you're saying this. And at one point, one of the judges was asking as well, like, listen, so you're saying that they're not entitled to a fair hearing? You know? And when you hear other judges come and ask certain opposing questions and stuff like that, it's good because you get a chance to have a level understanding and suss out what really going on. You understand? And it's a real good thing that this was allowed to be viewed by the public so we could analyze it ourselves. Big up to all the travelers who's been rocking out with us right here on Delta 9 Media as we pay attention to all the details in the CCJ with the leader of the win, Honorable Mr. Mohamed, the leader of the opposition as well. Back to regular programming.
In considering this matter, we are not yet in a position to give a decision on the application before us. Therefore, we are going to reserve until such time as we are so able. Now, the court is, of course, sensitive and aware of the fact that we are dealing with extradition matters, and these should be handled with expedition. But obviously, equally, we want to give due care and consideration to the arguments that have been put before us, and to ensure that the application is given due consideration. So we will have our decision as soon as is reasonably practical, given what I have just said. Two further things to mention. The first is just to emphasize that the interim stay of proceedings will obviously continue until the decision is made by this court on the application. And the second thing I'd like to say is that, of course, this court does not seek to regulate public commentary on judicial matters. We are well aware that counsel has a right to free speech, and we encourage the exercise thereof, of course. However, statements which are made outside of these proceedings and which could have the effect of undermining the fairness of the proceedings, or which could undermine public confidence in the administration of justice, should be avoided. And we would expect counsel on both sides to adhere to their professional responsibilities as far as that is concerned. We hope that that issue does not arise for any further comment by this court, but I am pretty sure counsel understands the need for proper behavior in this regard. And I say counsel, of course, on all sides. Well, thank you very much. Is there anything from counsel on this or any other matter?
Thank you very much.
You are most welcome, sir. Welcome. First respondent.
Nothing further from us. Thank you very much, Your Honors.
Thank you very much. Second respondent.
Nothing further, please, Your Honor. Thank you very much.
Thank you, sir. And third respondent.
Nothing from the third respondent, please, Your Honor.
Thank you, sir. Thank you very much. Thank you all, and we'll be in touch as soon as is reasonably possible. Madam Deputy Registrar, would you please close these proceedings?
Certainly. Thank you, President. Thank you, Madam Justice Rochnatli. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jamada. Thank you, Madam Justice Onoru. Thank you, Mr. Justice Ebowasuji. And thank you, Mr. Justice Balkan. Thank you, Counsel. And did I say Justice Jamada? If I did not, thank you, Justice Jamada. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you very much.
Thank you very much.
Telling you. We are see. Mind your words on both sides. Almost as if they were manners in. Listen, y'all don't realize what just happened there. Watch. No more conversation about the Mohammeds on issues in the news. What y'all think? What y'all think? What y'all just say right there? Drop it in the comment section. Call it in. Definitely. Hey. A win, but a temporary one as the deliberations go on. But I think after them outbursts that we had a chance to hear ourselves. I'm telling you. Yeah, exactly. It's like if you said it with a whole lot of innuendos and in one of the most punctual ways that you could. Right, Janet? Watch your mouth and don't get talking and saying certain things you know you shouldn't be saying as counsel on both sides. And he is on one of the sides. He is on one of the sides. You know? It's crazy. Yo, this is why you just gotta know when to humble yourself. Humbleness is key, buddy. Humbleness is key because one of the judges was kind of arguing for them, you know, from my perspective. One of the judges was kind of arguing for them. I don't know if you all noticed, but one of the judges was giving some rough conversation. Well, probably not deliberately, but you understand from my perspective. You see what I'm saying? Towards the Honorable Mr. Ford and Mohammed. When he was asking certain questions about bias, I was like, wow, how are they going to get any wiggle room around this? But, see, could have come on, be humble, get so far away that you sounding like you're disagreeing with the person that speak before you from your side. How it gets so far, man? Nonetheless, big up to all the travelers in the chat. Marva, thanks for being a part of the live. Marva is saying the question he asked. I'm not sure what that means. You got to explain or ask a better way. I'm not sure what you're getting at. The question that he asked. I'm not sure. There was a lot of questions being asked. I'm not sure which one you're referencing though. I'm guessing you'll probably scroll back. God and the truth will prevail. Janet is saying, yes, I observed that, but the AG came and blew a hole in it. I telling you, you see? Yeah. The questions that he was asking was saying, what, hey, like the senior, they said, nah. After they say, so when them gone, but nah, That wasn't it. Is why, listen, it pays to have good representation when you're standing in situations like that. Because listen, had it been anything or anybody else, or had it been a switch in representation, we clearly see what happened today. We clearly see what happened there. It could have went either way. It could have went either way. But at one time I was saying, it seems as if AG and the other side has got the leverage in this. The way that the judge was asking certain questions. You know? I see Dan saying this. Risedale Ford is a much more qualified lawyer than Anil. And we could see Anil is all bluff with no substance. This might be the first case we win in years because the CCJ lives in the PPP pocket. I don't know about that. I don't know about that because as we could see, it don't seem as if that's the case from these proceedings, but who knows? Who knows? All of that is just allegedly. Margaret is saying the CCJ is doing a great job. I definitely agree. Definitely agree with that. It was very interesting to observe the different sides and then to hear the judges interact with the case and understand just the way how legal minds would rationalize something like that. It was very interesting. Very interesting. I'm probably going to watch it back and I'm going to put up certain snippets so persons don't have to if they don't want to, but if they would like to, they can go through the entire thing. Because the entire live I'm going to leave up, but I'm going to put up snippets and pieces as well so persons can get those song bites. And the song bites will lead you right back to the entire live as well. So don't worry about it. We'll always have it up here so persons will be able. This is going to definitely be something that persons are going to be analyzing for a number of years, I can tell you. That was history in the making right there we were just watching. Persons are going to be studying that case, just like how they were studying that other case that they were referencing. And we got it right up here live on video, so we could study it, learn a lot from it as well. Big up to Rasta Empress, our moderator in the chat right now. Terry, what's going on? Bonita, thanks for tuning in. Desiree, everybody that's a part of the live, big up yourself. Ella, every single traveler that's in the chat, thanks for being a part of this live digital connection and for spending some time right here on Delta 9 Media. We are going to end the live so that it's not too long. Definitely we're going to come back and we're going to share some headlines, if not today, more than likely, or tomorrow. But nonetheless, look out for the updates, look out for the boarding, because you never know when the flight might be boarding, just like how this one started at a time when we don't usually go live. That's why I said, make sure you subscribe so that you can stay connected with everything that's trending in Guyana and in the diaspora. Cost you nothing to hit that subscription button and stay connected with every single thing. Pick up yourself. One love every single time.
A natural way to stay ready, baby. Cause I'm ready for you, Mr. C. The ultimate male supplement. Men's total wellness formula. Packed with essential nutrients for men's health. She'll call you Mr. C.